Please rise. Justice of the Appellate Division, Supreme Court, First Department. He, all persons having business with the Appellate Division, draw near, give your attendance, and ye shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division, First Department. I'm going to start by letting you know that we have 23 cases on the calendar, 7.5 hours of argument time. So today of all days, I'm going to ask you to please ask for the time that you need, not the time that you want, understanding that we are fully familiar with your case, the record, the briefs, and the clock is for you, not for the court. So even when I undercut your time, and I will, okay, trust that if my colleagues have additional questions, I will allow it to roll, okay? So if you're brilliant, you may get the time you actually asked for in the beginning, okay? All right. People versus Brahima Dijalo. Submit. Spring Scaffolding versus Croll. Appellate? How much time?
3 and 1, Your Honor.
Okay. 3 and 1 and 2. These gentlemen listen, thank you. Duangsi versus Duang is a submit. Forgive the mispronunciation, I'm sure. Asha Duning versus Adu. Okay. It looks like you scared away your opponent. Would you like to, are you the respondent? Okay. Is there, oh, that's the one that's, your respondent called and said he's running late. Tell me what time you'd like. Your respondent said he's running late, okay? But tell me what time you like. If he gets here on time, he'll get a chance to argue. Okay, so I'm gonna do 5 and 1, assuming your adversary gets here, and will afford your adversary 5 if he gets here on time. 437 West 36th Street versus ZDJ West 37 LLC. Okay. 5 and 1 and 3. Rosenblum versus Tritler.
Appellant, Your Honor, 7 and 3.
Okay.
Respondent, Your Honor, we also asked for 7 and 3.
All right, gentlemen, I'm going to give you 7 and 2, and it may go to 3, but depending on how the rebuttal goes, okay? All right. 7 and 2 for both, okay? People versus Anthony Balagar, and that case will be argued together if it's argued. It looks like it's a submit. Okay. Cuomo versus Jams, Inc. Okay. 6 and 1 and 7. Mirza versus College of Mount St. Vincent. Go ahead. Go ahead. Don't go based on what his number is, because that number is way overinflated. Tell me how much you need to respond. 7. Okay, let's do 6 and 1 and 7. Eisner versus Pascilico versus Pascilico Civil. Sorry.
Appellant, 7 and 2, please.
Okay. 5 and 1 and 5. K. Dorrell versus Delusen is a submit. People versus Stephen McKinnon.
McKinnon, Your Honor.
Sorry. Forgive me for the mispronunciation. How much time, sir?
6 and 2 should do it. Correspondent, 3, Your Honor.
4 and 1 and 3. People versus Jose Matias.
For appellant, Your Honor, 4 and 2, please.
Okay. 4 and 2 and 4. Emissions reduction versus McLeod Technologies.
For appellant, 6 and 3, Your Honor.
Okay.
Correspondent, 6.
All right. 6 and 2 and 6. McCraine Mungo versus Dag Hammarskjold Tower. Okay,
Respondent, Your Honor, five. However, the clerk's office did tell me to inform you, my name is not appearing in brief, but I gave them my information and
not a problem. 5 and 1 and 5. Delusen versus Equinox Group.
Appellant, 5 and 2, please.
Okay? 5 and 2 and 5. People versus Christian Compress Moreno. Okay? 5 and 1 and 5. People versus Josian Normal. Submit. People v. Joel R. Submit. Commonwealth Land versus Sky Abstract is submit. Narramore versus Mount Sinai Health is submit. Owens versus MTA is submit. First case on the calendar, People versus Dejalo.
Step up.
This one is a submit? Okay, sorry. Spring Scaffolding versus Croll. Thank you. You may proceed when you're ready.
Thank you, Your Honor.
Thank you.
Your Honor, the court below granted defendant's motion under CPLR 3211A4 and 2201 to stay the action pending resolution of a federal action. Quite a few cases of this court and other appellate divisions require complete identity of the parties.
Is it complete or substantial identities?
Your Honor, there are decisions going both ways. So there are some decisions stating that complete identity, meaning it has to be.
What does our department say?
I believe there are cases also going both ways. I believe there are some cases stating complete identity and some stating.
And those cases that say complete identity, how old are they?
They are some older cases, Your Honor.
So the more recent cases of this department say a different thing, right?
Correct, Your Honor.
So why should we not follow our most recent precedent, counsel?
Your Honor, even if this court follows the more recent precedent, we do not believe there is substantial identity here either, because the only party in common between this action and the federal action is my client, Appellant Spring Scaffolding. Mr. Croll is the CEO of both entities, and that's really all we have. Defendant did not.
The letter that is at issue here, that was written by Mr. Croll, right? The alleged tortious letter.
Correct. Mr. Croll or his attorneys on behalf of the entities, yes. And Mr.
Right,
Croll is
and
the
that issue is what's this issue of the scaffolding and using someone else's and copyright infringement, that is at the heart of the federal case, right?
Your Honor, the trade dress infringement is in the federal case, the patent infringement is not, and the copyright infringement is not. So those two other issues will not be decided by the federal case. And whatever the federal court decides, the liability will only be as to Urban Intelligence, Inc., not a party to the state action. So the only party in common here is my client, Spring Scaffolding LLC, Mr. Croll.
Counsel, I'd like to just follow up on what my colleague said. Now, Urban, and I'm just going to use the letters UUE, right? Now, they are related and they're both controlled by Croll, correct?
No, Your Honor. Mr. Croll, well.
Because I thought they were.
Mr. Croll, we believe, we'll just start with, there is no evidence of record because defendant put in no evidence about who Mr. Croll is or any documentary
What
evidence.
about the letter that was sent that's in the record? In that letter, there's a stamp, and that stamp bears the name of both of those entities, and it lists Mr. Croll as the CEO.
Your Honor, I believe those letters, the stamp is only of Urban Intelligence, Inc., the party in the federal action, but we're not limited by those letters. Those letters were put into the record to show that Mr. Croll had actual knowledge and was a proper defendant in this action. The letters were not put in relation to this argument, And we've alleged that the letters were sent by UUE.
But once they're put in, they can be utilized by either party for whatever argument they choose. And you'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. Patrick Cannell, Kaufman-Delowich for the respondents. The Supreme Court providently exercised its discretion in staying the state court action pending resolution of the same allegations, the same causes of action, and the same claim for relief by the appellant in the federal action.
Has anything been put forward to show that there was an abuse of that discretion?
Exactly. The appellant has not offered anything to show an abuse of that discretion, and we respectfully submit this court can easily affirm for two reasons. First, Your Honors, there's no serious doubt that there is at least substantial identity among Urban Umbrella Enterprises, Urban Intelligence, and Mr. Croll, who, as you pointed out, was the CEO of both the former entity and the successor entity. And the appellants have suggested that we haven't offered any proof as to the relationship among the parties, but they haven't addressed the fact that it's their own allegations that we relied on in the motion court, which we're allowed to do because it was a 3211 pre-answer motion to dismiss or stay. And secondly, Your Honor, and this is the critical point that the appellant did not address in its briefing, and Mr. Krimnis did not address to the court today, but regardless of the substantial identity of the parties, the First Department has held where there is substantial identity among the two lawsuits. That is substantial grounds for granting a stay. And while Your Honors can look at and compare the operative pleadings here, I think the silence of the appellant on this point speaks volumes, and we respectfully request that this be affirmed.
Thank you.
Thank you.
You have 1 minute.
Your Honor, opposing counsel here argues that essentially there need not be any identity of the parties at all. So it could be two completely unrelated parties as long as the claims are somehow related. Now, we're not arguing the claims are not related. They are related. What we're arguing is the parties are different here. We have Mr. Croll, who was the CEO of both entities, and we have two entities. And while there may be some relationship, we don't know what it is because defendant hasn't told us. Defendant had an opportunity to put that evidence in and chose not to. And finally, I will just note, Your Honor, that the legal standard for appellate review here is more akin to de novo than abuse of discretion. We cited on...
No, this is an abuse of discretion case, period. So tell me how the court abused discretion, because that's the only way you prevail here.
Your Honor, it abused discretion because there is no evidence that the UUE or Mr. Croll are substantially identical to Urban Intelligence, Inc., the party in the federal action.
Thank you. Ashanuddin versus Adu. Oh, still has not arrived. I'm going to give him another 15 minutes, if you don't mind, sir, to just give him an opportunity. I don't want to be accused of not affording a party a chance to argue, okay? Thank you. 437 West 36th Street versus ZDJ West 37 LLC. You may proceed.
Jeffrey Metz for the appellant. Your Honors, given the constraint of time, I'm going to address.
This is a simple issue. It's an issue of adverse possession on a property, adjoining property of two people who live next to each other. Go ahead.
Okay,
This isn't that
so
complicated.
The complaint was dismissed on an erroneous basis. This was a pre-answer motion to dismiss. And as the court well knows, all my allegations are accorded favorable inferences and must be assumed to be true. Now, if you look at 398 to 402 of the record, we go meticulously through all the elements showing adverse possession based on the pre-2008 statute because these walls were constructed decades ago. In opposition to that, all my opponent could come up with is he said there was no hostility. And why? Based it on this administrative code provision, which clearly does not comply here. Number one.
I think it goes beyond that. Didn't I believe one of the experts on 245 of the record, 246, 247, raised the notion that the retaining walls, because that's really what's at issue, I'm not going into the meats and bounds of that, were mutually beneficial. And if they're mutually beneficial, one, to keep the building up, the other to keep the erosion of the land from collapsing. I'm being overly simplistic, but you know what I'm saying, Mr. Matz. That mutual benefit of the adjoining parties kind of raises the hostility question out of the equation.
Well, Judge, I'll disagree with you, because number one, the retaining walls are solely on the property. They're not on my property.
That doesn't mean that it's not for a dual purpose, right? Because if you construct a retaining wall on one side of the property because physically that's the place where it should be in order to keep the earth from the other side from falling over, then the fact that it's on one property line is really not the issue.
Well, Judge, the issue is, first of all, there is nothing in their brief that says that this was mutually beneficial to them. They don't know anything about that because they're new owners here. They don't know what happened in the past. That has to be determined by discovery, followed by a trial. And again, this concept that this statute apply, it clearly doesn't, because it is not on the common lot line. As a matter of law, it does not apply. Now, they can say it's mutually beneficial, but there's nothing in their brief that supports that. They've come up with an alternate argument that my expert said that because he didn't know who constructed the walls, therefore it has to be permissive. It doesn't work like that, because all they said was that hostility was lacking. If that's the case, then the burden shifts to them when the other elements are satisfied. Set forth in our brief, it's very clearly that's what the law is. And they did not come through.
As I reviewed the papers here, your client kept on saying this wall was built sometime in the this or that, so that they don't know the answer to who built the wall and why.
Well,
so why is that not an issue that's determinative here?
it's not determinative because that is something that would be established after there is discovery. Just to say that doesn't make it true, Your Honor. You've got a tacking issue here. These are predecessors. These walls were built back in the 30s. So you've got you have a series of owners on each side. Now, by the way, I just want to make one thing clear. They have made clear that the encroachments are on their property. They haven't said that it was mutually beneficial. What they did was say, oh, and also what they wanted to do, if it's so mutually beneficial, Judge, why was their initial license agreement, they sought to remove the rubble wall? Why did they do it? If it was so mutually beneficial, why did they want to tear it down? They wanted to tear it down because they believe it interferes with their construction project. So you can't say that it was mutually beneficial because it's not. The record simply does not support that. And again, what they try to do after they said, well, now maybe we won't remove the wall, they'll say, well, we'll cantilever over the wall. That's no good either. That affects our property rights. Now, again, Your Honor, this is not a summary judgment motion. This is a pre-answer motion to dismiss. And you must adjudicate it in accordance with these principles that are, they're so boilerplate. I don't even have to state them to you, but you know what they are. And there is no, and by the way, one last thing, Judge, thank you. One last thing. They moved under 3211A7. Where's their extrinsic evidence? Where is their irrefutable evidence? There is no documentary evidence here. You have a statement by an engineer. That's not documentary evidence, Judge. And if you look at their brief, because I looked at it very carefully again this morning, there is nothing in there that supports any claim of any documentary evidence.
Thank you.
Good afternoon, Your Honors. May it please the Court. Simone Malinowski on behalf of Moreno Malinowski for the respondent, CDJ West 37th LLC. I think it's clear that Your Honors have reviewed the record and have gone through all of the various arguments proffered to the trial court.
Counsel, argue your case and address your adversary's arguments. I urge you.
First, the trial court properly determined that the retaining wall, which is on the shared boundary line, is mutually beneficial. Not only is that logically irrefutable, the entire purpose of a retaining wall is to prevent, literally retain what is next to it from falling over, but also the plaintiff or appellant's experts basically spent an entire brief in which they were seeking a temporary restraining order and then preliminary injunction, arguing that the retaining wall was necessary to preserve the structural stability of their property and to prevent the property from falling over to the respondent's property. Obviously, preventing a building falling onto my client's property constitutes a mutual benefit. With respect to the administrative code, which does apply here, the appellant spends a lot of time talking about the retaining wall being solely on our client's property. The plaintiff's own position is that the retaining wall is on both sides of the property line. The amended complaint, and I'm reading paragraph 10, the concrete retaining wall has a footing creating an L-shaped structure. Paragraph 11 of the amended complaint, the footing extends approximately 4 feet beyond the property line easterly into the 429 property. That's record 397. The entire purpose of the argument that was made before the trial court with respect to the preliminary injunction had to do with footing that was over the property line. An entire section of the appellant's brief talks about the below-grade footing being across the property line.
Counsel, just on a separate track.
Yes.
The claim for permanent injunction was dismissed.
Correct.
The claim for preliminary injunction or denying it.
Correct.
Was not granted. They have to meet the 3 elements, one of them being irreparable harm.
Correct.
Correct?
Correct.
And the court below found that there was no irreparable harm, even with their own experts.
Correct.
In terms of the digging around the retaining wall, et cetera, et cetera.
Correct. And the other, for just a purely practical point, all of the below-grade work has been done since March. It has been, I don't know, 6 months now? I lost track of time. There has been no claim that the building has collapsed or suffered any structural damage. We know that there was no irreparable harm because there has been no harm. Thank you, Your Honors.
Thank you.
Counsel must be reading a different record than I am, because if you take a look at their own statement, this is counsel's own statement. They say that their property survey, not mine, I'm not making this up, their property survey said that these walls were encroaching on his property, not joining the common lot line.
Mr. Metz, just to pick up on what my colleague asked you earlier, these walls were built in the 1930s as a result of the Holland Tunnel, and it was your expert.
Lincoln Tunnel, actually.
Lincoln Tunnel, I'm sorry, I don't have a car. It was your expert, if I'm not mistaken, went into the history and discussed how these walls were intentionally built back then by the predecessor owners to protect these properties, both buildings that were there, correct?
I'm sorry.
I'm sorry. Didn't your expert, the point is its history required these walls to be mutually beneficial.
Well, we don't know that, Judge. You don't know that. I mean, just be, 1 second, before I get to that. On page 22.
Well, didn't your expert say that in your expert's affidavit when discussing this issue?
No, he said that these were built during the construction of the Lincoln Tunnel. He did not say, because he's not a lawyer, he is an engineer, he said that it was built to make sure that the soil would not fall down and for structural stability of my building. Not that the building would fall over.
Right, and that equals to a mutual benefit.
Well,
a reading of what you just said equates to a mutual benefit.
I don't see that, Judge.
Oh,
I don't, Judge.
Okay, well, that's for us to decide. I thank you.
Okay, thank you.
Rosenblum versus Tritler. You may proceed.
Thank you, Judge. Richard Dolan for the appellant Kenneth Rosenblum. I'd like to start, if I can, with the prejudgment interest issue. And this really turns on the treatment of the statement in the court's prior decision. On the prior appeal, this court wrote, quote, "The trial court also did not improvidently exercise its discretion in declining to award prejudgment interest on plaintiff's withdrawal distribution." The record shows pretty clearly, as the trial court said herself, she just totally overlooked the issue. She didn't address it one way or the other. And this is the weird case, I think, where both the appellant and the respondent agree that at no point did the trial court ever address on the merits the issue of prejudgment interest.
Someone raised it at the appellate level, right? Which is why it became a part of the decision.
Yes, Judge. We asked you, and they quote the part of our brief in their brief at page 28. We asked this court de novo, I mean, you have the power to decide it even today, if you want to, the issue of whether...
We don't traditionally overrule our own colleagues, counsel, and that's what you're asking us to do, and I don't know any case where we've done that.
Judge, and I don't know of any case where the trial court, the appellant, and the respondent have told you that simply the record got misread the last go-around. The trial judge herself is telling you she never addressed the issue.
Right,
Okay?
she never addressed it, but
Yes.
on appeal, it was addressed. So her argument is that she's bound by that because it was addressed, and it was addressed because a party asked for it to be addressed.
Judge, we were the party.
Right.
We asked you de novo. We pointed out in the brief, the trial court never addressed this. We asked you de novo because as the appellate division, you have the power to do it. You declined to do that. And frankly, what happened, I think...
No, we made a determination.
No, what you said is that the trial court had providently exercised her discretion.
Which is a determination.
It happens to be wrong because she never
So
did it.
that's a different issue, right?
Yes, Judge, it
So
is.
it's not that it wasn't addressed. You think the decision was wrong.
I'm suggesting, Judge...
And you think our decision was wrong, which is what the Court of Appeals is for.
Yes, but they don't, all I can say, Judge, is this is an appellate court, and you're in the business of fixing mistakes, and we've identified a mistake.
Well, let's talk about the discount for lack of marketability.
Sure, Judge.
What was your argument about what that rate should be, and what did you base it on?
Our argument was that it should be 0 or at most 3 to 5%, which is...
You didn't argue that below.
Yes, we did, Judge.
3 to 5? No, your expert said that, but your client continued to say 0.
Yes, it was in the
So
alternative.
that
yes.
seems to be a position that you are fixed with today.
That's okay. I'm happy with that position because I think it's the correct position. Basically, on the discount...
But in fairness, the court had the right to be able to weigh the credibility and determine that your friend's appraiser putting the DLOM at 15% was just a fairer number.
Judge, I think it's ultimately a question of law, and let me explain that, okay? In B-Way, which is the controlling decision, everyone agrees, Court of Appeals, they said it's a two-part analysis. The first is at the entity level, that's the LLC level, you determine the value of the property. And once you do, and the trial court did that, and no one is disputing the number, it's $22.6 million. The second part of the B-Way analysis is the court is to ask whether the interest of the plaintiff is liquid, meaning is it readily convertible to cash. As a matter of law, plaintiff had the right to withdraw from this LLC at any time.
Right, but the issue about whether it's liquid when what the LLC is holding is real estate becomes a very different issue, right?
I respectfully disagree, Judge, because this is a matter...
Just because you decide you want out of your interest doesn't mean the market will bear the number you think it's worth.
The number...
So what the value of a company is what a buyer is willing to pay, just like real estate.
Yes, I understand that, Judge. And what the buyer would buy is what we had, a right as a matter of law to liquidate the interest and a right as a matter.
But the question is, how easy is that, right? Because this case has been going on for quite some time, so it's not that easy for it to become, for you to get your liquid value out of it.
Judge,
And the court's assessment that a future investor would look at a company like this in disarray and in insular fighting amongst the members is not as valuable as one that doesn't have that issue. So it seems to me that the court's assessment on that was correct.
let me address all of that, Judge.
Well, you know what, can you add this question on as well? Because what I would like to know is how can, you know, the membership interest be easily converted into cash because there is no operating agreement. So can you address that as well?
Sure, Judge. And again, as a matter of law, a member of this LLC could withdraw at any time. He doesn't need anyone's consent, no permission. As a matter of law, by statute, if he does...
That's not the issue. The issue is, what is your interest worth after you elect to make that decision?
And the statute answers that as well.
Okay.
It's fair value paid within a reasonable time after withdrawal. That's it.
How long has this action been taking?
This action's been pending 2015 approximately. Judge, if you...
Decade, right?
Yes, and there are many other issues besides this. This is the whole trial that we had in 2020.
But that goes to the issue of a buyer buying into or buying the company when it takes a decade for this person to get out of the company and get any sort of value out of it.
Again, Judge, I think
liquid value.
on this issue, we've had many disputes in this case. On this issue, we were granted summary judgment. Why? Because the statute is as clear as a bell. We have a right to withdraw. And then when we had the first trial, we did, and that's what happened. And if you're suggesting that the liquidity of my client's interest depends on the ingenuity of opposing counsel to generate litigation and delay.
Those are your words, not this court's, and I would urge you not to do that.
Okay, Judge. All I'm telling you is litigation can be dragged out. We all know that. We've all seen it.
Everyone on this bench understands that.
Okay.
A part of that assessment, though, is if you have an operating agreement, and that clearly defines how you're able to get the liquid value out of the partnership.
I have better than an operating agreement. I have a statute, okay? And the statute says I'm entitled to be paid fair value within 6 months of withdrawal. Withdrawal happened, according to the court, in 2019.
You'll have time on rebuttal. Thank you.
Thank you, Judge.
Good afternoon. May it please the court, Patrick Petroselli on behalf of respondent. Taking up briefly the point of interest, I would just add, unless the court has any specific questions, that someone did in fact raise it. It was the petitioner, the plaintiff, who raised it. He asked this court to make a decision, and the court did. We believe that that issue has been decided and that the trial court properly exercised the discretion that she had, which was to follow this court's decision. If there are no questions on that, I'll move on briefly to the discount. The statute that the petitioner relies on gives him the right to withdraw and then seek fair value. Fair value is an issue that then becomes subject to dispute. There were reasonable disputes here as to what the fair value was, and that takes time in litigation. The fact that there was no operating agreement means that there needs to be a discount, and we believe that the trial court, again, providently exercised her discretion by adopting the estate's expert's valuation and the estate's expert's discount. So unless there are any questions on that.
Has there been any contradiction, any opinion that goes against what you just said, that where there is a company such as this without an operating agreement, that by virtue of that fact alone requires a discount on the value of the asset, because the investor going in is going into a field of uncharted waters where anything goes?
I don't believe there's a case that says the lack of an operating agreement means that you need to apply a discount. What I think that the case law from B-Way on down has consistently held is that it's a facts and circumstances test that looks at all of the appropriate circumstances, all of the relevant facts leading up to the valuation date.
And one of the critical factors here was the passing of the HSTPA.
I'm sorry?
Isn't one of the critical factors was the HSTPA that would have affected the value of the building because there was rent-regulated tenants in these buildings?
Yes, absolutely. So
And that was one of the reasons why, when you have that kind of problem, the higher the cap rate, the lower the value in terms of calculating this, correct?
exactly, Your Honor. And so
And while one of the buildings had a small number of rent-regulated tenants, the other building had 33%
that's correct.
rent-regulated. And certainly that would impact the value of that building.
Correct. And that brings us to the estate's appeal.
Can I just ask you a question regarding the discount as to the operating agreement? Why is it so complicated? If it's 50-50, why would there be a necessity? If you split it 50-50, the operating would just say 50-50.
Sure, because what B-Way requires is you to look at the illiquidity of the petitioner's shares. And so what you're talking about is, could the petitioner sell his shares on the open market and at a fair value, at a fair price, quickly, to Your Honor's point? It needs to be a liquid asset, readily convertible to cash, which is not true here. So regardless of whether it's 50-50, the fact that you have no operating agreement, you have no ability to manage what the sale process would be, you have no ability to go to the market. If the petitioner really thought that this was a liquid asset, rather than seeking a business divorce through litigation, he could have sold it to a willing purchaser. That market doesn't exist, which is why the trial court correctly found that that no one would buy this, let alone without a significant discount, and she exercised her discretion reasonably by adopting the 15% discount offered by the estate's expert. Now,
Can you speak to the issue of the loans and how that factors into the valuation?
the loans didn't factor into the discount. What happened was the parties jointly owed the LLCs that were being valued money separately through another partnership. And what the court did was she said, well, since the partners are responsible for the loans and the partners owe the LLCs the money, what will happen is that partners are each responsible for 50%, so the money goes back into the LLC, and then when the money comes out, the discount is applied to petitioner's share because he's entitled to his fair value, which incorporates the discount for lack of marketability.
So the loans were basically offset.
The loans were offset going in, and then when they went out to the petitioner, he took the same discount on the loan because he doesn't have a liquid share that was being liquidated.
The way that that works, does it give the petitioner the full value of the loan offset?
It gives the petitioner the full value of what he's entitled to, which is the fair value of his interest in the LLCs, which includes the 15% discount for lack of marketability. So if I can move on to the issue of the property, there was really, I think, overwhelming evidence that the value of these buildings declined. That was clear from the petitioner's own affidavit, where he said twice that the value of these properties, I think the second time he said drastically declined, and one time he said it specifically declined by about 20%. And it was perfectly bookend around the actual valuation date, because one of the affidavits that he submitted was in March of 2019. The valuation date was September of 2019. And the second affidavit was February of 2020.
The comparable values that you put in, were they similar buildings to the actual property here?
There were distinctions between the buildings, and we believe that those distinctions are appropriately reflected, allowed to be done in an analysis.
What were the distinctions?
I'm sorry?
What were those distinctions?
There was differences in location.
Doesn't that make a difference when you're talking about property value, where it's located?
It makes a difference, but Your Honor, what the capitalization rate approximates is what's a reasonable return on your investment. So you say, I'm going to have this income stream. How much would I pay to get that income stream? And that gives you a return. So what you would essentially be saying is that you would accept a lower return on a building just to own it in a particular location, which we don't think is a reasonable inference to be drawn. If you're going to purchase a property because you want a specific return, you're going to want that same return regardless of where the property is located. And that's why...
Well, where it's located will command what kind of return you get on the property, right?
Well, where it's located will demand the income that the property can generate, but the investor who is actually purchasing the property is the one who decides what's the appropriate return that they expect from that they expect from their investment. And we submit that wouldn't matter where the property is located. You might have,
But
Are
if
you
you're
kidding me?
comparing properties.
Are you kidding me? You're telling me that a piece of property in a middle village in Queens or a small area in the Bronx is the same as a property in Manhattan? Never. No day of the week.
I'm not saying that the properties are the same, Your Honor. I'm saying that the investors in those properties would accept the same percentage of return.
Right, the percentage of return that they accept is going to be different based on what they're actually getting, right? So
And
it'll be
where the
higher.
property is located.
It'll be higher, that percentage of return. So that's why you have to select a similarly situated property regardless of what the return is, so that you can have that base value that's the same.
And if I could address that question, Your Honor, the problem that we faced here was because of the new law being passed so close to the valuation date. It was June of 2019. The new law was passed in September of 2019. There was a period of price discovery. Their expert talked about the fact that there was basically a pause in the market to assess how the new law was going to impact the value of the buildings. And so we did the best that we could to find properties that were sold around the time that the new law had passed, so it would accurately capture the period of price discovery. Conversely, with respect to plaintiff's expert, he admitted on the record that his comparable properties that he selected did not capture the period of price discovery that he himself identified was going to be occurring.
Okay. You have 2 minutes.
Your Honor asked a question about the number of units in the two buildings, and one
I
was...
didn't ask that. Maybe someone else did.
33%, well, somebody did.
Yeah, oh, yes.
Okay, and that's correct as to the number of units, but what matters is the dollars. How much of the income of the building is generated by rent-stabilized units? And not surprisingly, in that building, it's only 10%, as the record shows.
Yeah, because rent-stabilized units garner a lot lower rents.
Yeah, absolutely.
So that's not surprising at all, what
It
you
isn't.
just
But
said.
but what matters is that 90% of the income comes from non-regulated units. That's why the value is higher. And on the other building, rent-regulated units only generate 2 to 3% of the income. They're almost irrelevant for the second building. But in terms of this whole business of on the cross appeal, that's what I want to address quickly. I think Judge Crane said it better than I could, so I'm just going to read to you what she had to say about this. Counsel told you that there was almost no dispute that the values had gone down. This is what Judge Crane said. It's on page 8 of the record, and as I say, she says it better than me, so just let me read it. At the 2020 trial, defendant's prior appraisal of 132 Thompson as of 2016 amounted to $23.4 million. Yet valuing for 2019, 3 years later, the appraised value decreased to $18.5 million, a 21% decline in value. Defendants proffer no explanation.
Counsel, I can assure you, we all read that.
Okay.
I read it and understood exactly what the judge said. So tell me what your argument is from the judge's finding, rather than reading me what I've already read.
Again, is there something that Your Honor pointed out? Location matters. She quotes their own expert at testifying that property in the West Village was not declining. It happens to be the most valuable neighborhood in the city, and in those years, the values were going up. That's on page 8. She actually spends about 2 pages in her decision discussing this. Yeah. Thank you, Judge.
Thank you.
You got the point.
Trust me, we will look at the papers.
Thank you, Judge.
Thank you. All right. Cuomo versus Jams.
No, I think he...
I'm sorry. You still have 2 minutes.
That's okay, Your Honor.
Give me 1 minute. You're next.
I'll be very brief.
Oh, they're here? Okay, not sure.
I don't think I
proceed. Go
don't
ahead.
think I need to say anything with respect to the
Well, why
percent.
don't you respond to that?
I was going to say,
Regarding the property value that initially you put in versus the second property value and it declining that much in a property located in the West Village.
first of all, petitioner, his client, submitted an affidavit 3 months before the valuation date where he himself attested to the fact that the value of these properties declined by 20%. That is the exact same decline that my friend on the other side just quoted here, as if it was somehow outlandish that we would find the same thing that his client attested to the court. I think with respect to
So if the court doesn't believe both of them, His client or yours? What do we do with that?
Well, the court did believe his client because she adopted his client's appraiser. I think what, you know, there's a...
My point is, she didn't believe that there was a 20% decline in that neighborhood.
And I think part of the reason why she made that finding was because because the trial court indicated that she thought that the estate's motives had changed between 2006, between the trial in 2020 and the new trial in 2023. Her finding was that we must have gerrymandered this decline in value because we had previously been getting bought out, and then we were going to be the party being...
Doesn't that go to the credibility of the determination of the judge, and the judge made a finding that was credible? And I do it all the time when I was doing eminent domain. We have experts, and you believe some part or not. Why couldn't the judge just make that decision?
The judge certainly has the ability to make credibility findings.
Why should we change it?
This court, as in the standard review cases that we cited, does have the ability to make whatever finding.
Yes, but why should we change it is the question. We know we have the power to. Why should we exercise it?
The court should exercise that power because there was overwhelming, undisputed evidence that the new laws caused the value of all properties in the city to decline. That was a finding that this court made when it described the new laws as a... I forget the exact quote, but it's in our brief. It was a watershed new law. That was a finding that their expert agreed when he said there was going to be a period of price discovery and that all cap rates were going to increase, which means values would decrease as a result of this new law, that his client attested to and that our expert attested to. So you had a situation where everybody agreed, and the trial court went the other way, and we think that that would be an abuse of discretion.
Thank you.
Thank you, Your Honors.
Are the parties for Ashadun Adu here? Please come up. He's not here? Come on up. I'm going to allow you to argue. What time is it?
2:47.
It is now 2:47. Counsel called saying he would be 45 minutes late. He is now 47 minutes late. Counsel, you may proceed with your argument.
Thank you, Your Honor. Eric Berry for the Muhammad Asanuddin. I think this court's decision in 2019 got a lot right, got everything right. It asked the question, how, if the seller, the autos, the defendants, couldn't sell it to us, how, if that was impossible, could they simultaneously be selling it to somebody else? In the court below, neither Judge Perez nor the defendants answered that question. The decision, this court's decision in 2019 was based on a lot of insight. It recognized that a self-created possibility is not a defense, that a title defect or a self-created title problem does not justify a remedies limitation defense, and implicitly it recognized that a Chapter 13 Chapter 13 debtor can always dismiss its case. If a dismissal of the case comes before there is an approval by the court of the purchase contract that was entered into during the Chapter 13 case, that is a rejection by the debtor. It does not terminate the contract, but it breaches the contract. The United States Supreme Court.
Sir, the bottom line is you believe you should have a breach of contract claim against the autos.
Pardon me?
You believe you should have a breach of contract claim against the autos.
There is a breach of contract claim because the autos.
He's agreeing. He's agreeing
right,
with you. Is that your position?
Right. I just wanted to know that this has been dealt with by the United States Supreme Court. This specific issue. It held that a rejection by a bankruptcy debtor breaches a contract, but does not rescind it. And that means that all the rights that would ordinarily survive a contract breach, including those conveyed here, remain in place.
So tell me, counsel, what is it that you like this court to do?
Okay, so there was a sale behind our back that was to another buyer, which happened to be the seller's attorney's other client. That should be vacated or rescinded or voided. The reason is Real Property Law 291, specifically, case law under Real Property Law 291, specifically states that if a buyer has constructive notice of a prior claim, that constructive notice precludes him from being a good faith purchaser for value.
Counsel, even if that's done, though, based on the terms of the contract here, you're not entitled to specific performance, right?
We are.
But the contract specifically says that you're not entitled to that, that the only damages per the contract is that the down payment is refunded.
That's the remedies limitation defense that I mentioned earlier. The Second Circuit decision it's called NASO. This court's, not Second Circuit, Second Department's decision in NASO, this court's decision in MOCAR, and all the decisions we cite in our brief state that if the problem that prevents the closing is a title defect that is curable by the seller or a self-created impossibility alleged by the seller, then those remedies limitations defenses do not apply, and you're not limited to that remedy. You're entitled to receive any remedy that the common law of the state provides you.
Isn't it true that the First Department is contrary to that view?
No, I don't think so. I think the cases in MOCAR, this court's decision in MOCAR, basically agrees with all the other departments here.
We would state our own position.
Well, this is the decision.
Counsel, you have 4 seconds left. We will
Okay,
take a
well,
look at
I believe
MOCAR.
you look at MOCAR v. Hall is expressly
We'll
on
take a
point.
look at it.
That's this court's decision, I think, from 1958.
Thank you.
And I don't think it's ever deviated from that.
Thank you so much. Cuomo versus Jams. You may proceed.
May it please the court. My name is Tina Glandian, and I represent the appellant Christopher Cuomo. At its core, this appeal is about preserving the integrity of arbitration as a neutral dispute resolution process. The trial court's ruling, which denied limited and tailored discovery.
So going against the rules of the arbitration courts and of Jams, where they have made their own determination on this issue, and then seeking to not only ask for discovery on the underlying action, but now seeking discovery on this tangential issue of whether the arbitrator should be disqualified, you think is an appropriate course of action in light of the case law on this issue?
We do, Your Honor. We think the fundamental issue here is that arbitrator Sonnenberg did not just fail to disclose this. He directly denied the existence.
No, he said he was unaware, that he did not know. That is not a denial. That is never was there a case with my firm and CNN. That's not what he said.
And in fact, he said that the firm potentially did represent CNN at some point.
I don't believe that's correct.
So what did your client's lawyers do to do their own investigation? Because of course, court records and stuff like that is pretty publicly accessible, to try to find out, since the arbitrator said, I don't know. He didn't say there wasn't, he said, I don't know.
So that's not in fact what he said in his initial disclosures, and if it's okay, I'll read the direct quotation. There's a distinction between question 4 and question 5 in the disclosures. As to question 4, when it asked about whether there was any prior attorney-client relationship with any of the parties, he specifically just answered no. Not I don't recall. The I don't recall came later when...
No, we're talking about the other question in the disclosure regarding the law firm.
So that was question 4D, and that was not about a prior attorney-client relationship. That was in his role as a neutral. And so that's very different, because if he had said, I don't recall, or I'm not sure...
So typically, when you go to hire a lawyer at a law firm, the law firm will say, they'll talk to you, and then they'll say, okay, but I have to do a inside search to make sure that the party you're suing is not someone we represented. Under JAMS, this arbitrator did not have an obligation to do that.
And I'm glad Your Honor brought that up. He represented that he did that because there was a declaration to his disclosures, and he went on to specifically say that he did his due diligence, that he's looked into these matters, and that his representations are made after a diligent search. So it's akin to you going to a law firm, the attorney saying, let me run a conflicts check, pretending they ran a conflicts check, telling you there's no conflicts, and then you say...
He's not required.
But he represents...
He is not required to do a conflicts check on his prior law firm, and some JAMS mediators come from several firms, not just one. Okay, so they cannot be expected to know all of the clients that the law firms they were with represented, counsel.
Absolutely, and if he had made...
Counsel, in fact, aren't the people who submit to the arbitration required to do their own due diligence?
This is not, the direct attorney-client relationship was not
Answer that question.
Well, I don't...
Your response is not an answer to her question.
So my response is, I don't...
Are you required to do your own due diligence was the question. Is that a yes or a no?
I think only if there's a representation that gives rise to you believing there might be...
Where in the record is there evidence to support what you just said?
So in our opening brief...
That only if do I have to do my own check. Where in the record, where in the agreement with JAMS does it say that? Tell me what provision, what page, what line?
Well, I think the declaration that he submitted basically...
No. You're talking about something else. I need you to stay focused on our questions, because this is very serious. Article, when we do arbitration, it is supposed to be a means to avoid this.
Correct.
Right.
And if someone makes accurate disclosures, we wouldn't be here. If he even said, I am not sure, I worked for a big firm, then we would be on notice to do our own diligence. But he didn't. He said no.
Explain to me why it took over a year to make this application. You received 39 rulings, and most of them in your favor.
It was only, these were all preceding issues. I don't think there was anything particularly favorable to us, but there was no reason for us to investigate.
I'm sorry, you said that you don't think that there was anything particularly favorable to you, but you had agreed, or, the lawyers in the arbitration agreed that they would move forward with a different arbitrator, keeping the same rulings that were previously made by the arbitrator.
It's important that was just a hypothetical because, and I hadn't discussed that with our client.
Did that happen or not?
Did what happen?
That you put out that you would take a new arbitrator, but you would keep the prior rulings of the current arbitrator.
Yes, I proposed that as a hypothetical to avoid having to relitigate 1 year, which is also expensive.
As a hypothetical?
Yes.
So if you thought that there were biased orders by this arbitrator that your client now wishes to disqualify, why would you not contest any of the orders that you thought were biased?
They were not, we never argued that the orders were biased. They were insignificant rulings, and it was on the eve of the plenary
39 insignificant rulings. You'll have time on rebuttal, counsel.
Thank you.
Good afternoon, Your Honors. I agree with Ms. Glandian that this action is about preserving the integrity of the arbitral process. And the
Counsel, can you speak to the disclosure that was actually made by the arbitrator and the nature of that disclosure, and whether, in fact, that did put the other side on notice to do their own due diligence?
Counsel, please put away your telephone.
I apologize. I thought I was allowed to look.
No, you're in the middle of oral argument.
Your Honor, to answer your questions, and I'm glad you asked it, and I'm going to read from the disclosure, and this is on page 188 of the record. Arbitrator Sonnenberg said, I was a partner at Paul Hastings until January 2018, and it is possible that the firm was aligned with or was adverse to a party in this matter or counsel in this matter. He made the disclosure.
What we're ultimately talking about is some representation that involved CNN, that the payment was $3,000 a decade ago, right? That's what they ultimately.
2 decades
More,
ago.
more than 2
2003.
decades. Okay.
And it was a handful of hours. You know, arbitrator Sonnenberg worked at Paul Hastings for 35 years.
And we're talking about Paul Hastings, so a $3,000 bill could be one phone call.
Correct.
And a follow-up.
And if you work 2,000 hours per year, that's like, 70,000 hours. And he couldn't remember a matter for which he spent, maybe an hour, maybe more.
I have a question. The rules that JAMS mediators have to follow with regard to disclosure, are those made available to litigants?
Absolutely, and we include them
Okay.
in our record on appeal.
And is there any allegation that the arbitrator did not follow the explicit direction of his JAMS contract with respect to disclosure?
No, Your Honor, and as you were asking Ms. Glandian, you said, was there a duty on the parties to do their due diligence? There absolutely was such a duty, because the disclosure put the onus.
Does the arbitrator have an obligation under their JAMS contract as an arbitrator to do a conflict check on any possible litigant that is before them? What is the extent of that requirement?
Not a conflict check of his prior firm. And there's case law on that. There is no duty to do a conflict check of a prior firm, and such a duty would be unworkable. You don't know whether the former law firm is going to cooperate with the arbitrator. That would make, arbitration expensive, and that's the whole point of arbitration, is to avoid costs. Here, Mr. Cuomo was on notice, and he doesn't dispute that he was on notice, that Mr. Sonnenberg worked at Paul Hastings, he worked at Paul Hastings for 35 years, and there was a possibility that Paul Hastings was aligned with one of the parties. He did not ask any questions.
After there is a disclosure, after parties select prospective arbitrators, and the arbitrators then submit their disclosures with regard to this particular issue of potential conflicts, is there a period of time in which the parties can then object to a prospective arbitrator and say, not that one?
Right, they don't have to select that arbitrator. The disclosure tells the parties, here's the disclosure. If you have any questions or need any additional information, let us know and we'll set up a call. Mr. Cuomo never objected, never asked for additional information, and agreed to this arbitrator. And Your Honor, he did stand by all the orders. And again, this is on record on page 242. This statement.
And were those 39 orders insignificant orders of no import whatsoever?
Your Honor,
as your colleague just described them?
I'm not familiar with the substance of the orders, but I can tell you that Ms. Glandian on the record said, we had to dig rather deep to finally establish this relationship. And it's not that we didn't like his rulings. He's been presiding over this case for over a year at this point, and we've stood by all of his rulings. So for a year, they arbitrated. They had no issue with the arbitrator. And all of a sudden, on the eve of the arbitration, finally, they think, oh my God, this arbitrator is biased because he didn't respond to us immediately during a weekend, during a Father's Day weekend. And then we get to—
Well, counsel, what they said is that they became baffled by the arbitrator's indifference to the unfairness baffling them. What happened?
So I'll tell you what happened, Your Honor. There was a leak of confidential information. CNN asked the arbitrator to order Mr. Cuomo to provide an affidavit concerning the leak. So the arbitrator, being the neutral and unbiased arbitrator that he was, he ordered both sides to provide disclosures. And in fact, Mr. Cuomo's counsel praised that decision, that both sides had to provide disclosure. After the disclosure was provided, Mr. Cuomo asked for certain rulings on the day of the hearing, and the arbitrator granted most of their requests. He agreed that Mr. Cuomo could depose a potential leaker from CNN. He also denied the CNN's request to loosen remote participation requirements. He granted Mr. Cuomo's request that CNN employees not participate remotely during the arbitration hearing. The only request by Mr. Cuomo that arbitrator denied was a request to depose CNN's counsel. So I'm just confused as you are, Your Honor, as to why they were baffled by this injustice, because most of the rulings went to his favor. So, you know, this
And that's when the request was made for the disqualification.
Well, actually, not even then. Mr. Cuomo said, asked to disqualify CNN's counsel. The arbitrator said, I cannot do that, it's beyond my jurisdiction, you have to go to court. Mr. Cuomo then said, well, stay this arbitration so we could go to court. It was only after the arbitrator said, I will not stay this arbitration, that Mr. Cuomo said, oh, we want to disqualify you because, you know, you're biased.
Well, they said they were baffled and they spent the weekend trying to unravel the bafflement.
I'm sorry, Your Honor?
They said that they were baffled by that ruling and they spent the weekend trying to unravel that. So the lawyer went over the weekend digging into the background of the arbitrator.
So the ruling actually came after they did the digging. They did the deep dive, which was just a Google search over the weekend, and then the rulings actually came in on Monday during the arbitration hearing.
Which could have happened a year ago.
It could have happened a year ago.
Thank you.
Thank you.
Counsel, when you started your Article 75 to seek a stay, and it's pretty rare in the middle of an arbitration to do that seek that sort of relief, did you have any evidence of overt bias during that entire year of arbitration to put forward before Justice Maisley to somehow give yourself some legs here? Because I couldn't find any.
So again, on the morning of the plenary hearing, when we had uncovered the fact that there had been, we didn't know about the direct attorney-client relationship between the arbitrator and CNN because that was not discoverable until CNN disclosed that, not even on the day of the plenary hearing, but after we filed our OSC in Superior Court. But the morning of, when we raised this issue with the arbitrator, he tried to force us to proceed, which is not within his province. The rules, the JAMS rules require that to be a determination made by the JAMS board. And he overruled us and tried to force us to proceed with opening statements, given the fact that we had raised this issue with him. So that was one issue that we were certainly aware of that we put before Judge Maisley when we initially went in for the TRO, and she agreed with us and granted the TRO. And at that point, CNN disclosed for the first time the fact that there was a direct attorney-client relationship with arbitrator Sonnenberg, something we could not, despite any deep dive, uncover. That's not something...
Are you referring to the 2003 matter?
Yes, but we don't know if that's the end of it, because arbitrator Sonnenberg says he has no recollection. He never, in his declaration, he didn't say, given this information that I didn't remember, I reached out to Paul Hastings and they've confirmed there were no other matters. He never took any steps other than just saying, I don't remember, even when it was proven by CNN that there was, in fact, at least one representation. He never took any steps to verify it.
Can we agree that a $3,000 payment for his representation could not have been much of anything?
Well, we don't know if it was $3,000, and he also...
That's what the records show. That's all we have. We have nothing else to show that it was anything else.
Because we can't, it's within third parties' knowledge. We would have to have discovery to uncover the information, and we were denied that opportunity.
Thank you.
Thank you.
Mirza versus College of Mount St. Vincent. You may proceed.
May it please the court, my name is Michael Diedrich. I represent Roma Mirza. A Muslim man from Pakistan, not unlike Irish, Italians, Hispanics, Jews who came to the country. He came to this country, became a taxi driver, paid for his daughter, Roma Mirza, who's in the courtroom here today, to go to college where she did well because she wanted a career in healthcare. Then she became admitted to the PA program of the College of Mount St. Vincent, where she did fine. She was elected vice president of her class. She was so proud of this that she wanted her college friend to maybe apply and maybe also become a PA student in that program. So she wrote a letter of recommendation for her friend. She put it on a form that was clearly indicated that she's a student, and she apparently, we don't know for sure, because she doesn't remember, she apparently took a template from some PA who wrote a letter of recommendation.
So, counsel, we're talking about the discipline after all of that transpired, right? And whether, in fact, the discipline is so harsh that it shocks the conscience. Because that's really the only way that this court can weigh in on a private institution's discipline of a student, correct?
No, Your Honor, because, no.
Counsel, I suggest you hear that question carefully and answer it.
I did, Your
okay?
Honor. The reason academic institutions have a broad discretion is in academic matters. So when you grade somebody with a B or a C or an F as opposed to an A, that's not discipline.
They don't have broad reach in terms of how they discipline in general a student for violating their rules?
I would say it's fundamental contract law. When you apply and become a
Counsel,
student.
again, I'm going to urge you.
To listen to the question.
Yes, because we are confined by a very strict body of law. And we only have very few ways out if we think that the decision below was wrong. Not only wrong, but beyond the authority of that body, okay? So issues of contract law don't weigh in here, okay? I need you to focus on the standard we must apply. So again, going to my colleague's question, explain to us why this punishment went so far beyond the alleged infraction so as to shock the conscience of this court and allow this court to do something about it.
Your Honor, it's draconian to expel a person for making an innocent mistake. As I pointed out with attorney discipline.
Let's talk about that innocent mistake.
Yeah.
Because that's important here, right? So the application, the submission, your client puts in her student email.
Yes.
Correct? In the first couple of sentences of her letter, she identifies herself as a student.
Correct, Your Honor.
Correct? So that anybody who actually read the entirety of the submission knew she was a student and, ooh, this marcation at the end of her signature must be a typo.
No reasonable person could believe otherwise, Your Honor. It was so obvious on all scores. Plus there's lies from the institution. The director of the program repeatedly, and this was then parroted by everybody else.
Your focus is the fact that through the entire chain of the process, through the initial committee meeting or hearing to the APC committee, all the way up to the provost of the school, they relied on an impression or a misimpression that she actually digitally signed her name with PAC, which she did not, correct?
Even worse than that, Your Honor. It wasn't a misimpression. Dr. Gallifrey specifically told everyone, and this was parroted on, that she signed her name, Roma Mirza, PAC, when the document itself, you can see the electronic version, had a digital signature, which was Roma Mirza, and then a student email address. The PAC was down in below that,
outside of the signature box,
like a signature block. And as I was referring to attorney disciplinary matters, when you do an accidental mistake that's venal, attorneys, if I accidentally say to this court, I'm representing the respondent instead of the plaintiff because it's a mistake, and I don't correct it, it's wrong, but it's not disciplinary wrong. There's no intent to mislead here, and there was no misleading. There's no evidence that
Counsel, I like to turn to the hearing itself, because at the hearing itself, petitioner was under the impression she was being called in because she was not permitted to write a recommendation letter, and once she learned it was because of the use of the PA-C designation, she was a bit caught off guard and indicated it was a mistake and not intentional.
No, Your Honor, she was given no notice of why.
No, I'm saying, but once she got there,
When she got in there, then she was basically sandbagged with the accusation. So what I'm saying is evidence of not only just arbitrary and capricious, and with all due respect, The issue is not only discipline, it's did the college follow its rules? It violated its rules over and over. Its rules said fairness, discipline. So if we say contractual due process, if you will, because it's not a government, but due process principles, they gave her no
So she was invited to a meeting,
and then,
was not told why she was invited to the meeting, was not given any opportunity to prepare a defense. She had to do that on the fly in the presence of these 9 people.
in 4 minutes.
Okay?
And then,
do I have this right?
correct.
Okay.
Exactly. And then
You'll
after,
have time on rebuttal.
and
as
then
you
just
see.
one other point.
Counsel,
Yep, thank you, Your
you'll
Honor.
have time on rebuttal.
Good afternoon, Your Honors. May it please the court, Rebecca Kimura on behalf of the respondents.
I like to pick it up at the hearing because once the petitioner was advised that she had used the PA-C credentials, I believe she stated, and I'm going to paraphrase, that she was sorry, it was a typo, she meant to write PAS, which was a student, and it wasn't intentional. Pretty much, that's what petitioner had indicated during the hearing.
That's correct, Your Honor.
Why was that ignored? Completely ignored by that body.
It wasn't ignored, Your Honor.
Apparently, because the entire application that she put forward, her entire submission, had her student email. As I said, the letter identified her as a student. That seemed to go right over the head of this panel. Why?
I just want to add, if I can, that petitioner listed herself as a student 3 separate places in the recommendation letter.
Your Honor, she never, she never denied the fact that she put PAC after her name.
You are ignoring our question. Why is it that a letter that says, I'm a student, oh, by the way, I'm a student, oh, and again, I'm a student,
3 times.
that gets overridden by these 3 little letters that are outside of her signature line, and this institution thinks that this is a fair and proper way to treat its students?
Your Honor, if I may, it was considered, the fact that she said it was not intentional was considered, but the fact that she admitted that she did put PAC after her name was
She
the
didn't
important.
admit that. She
I
did
think
not
you-
admit that.
I'm sorry. May I?
Yes.
I think you mischaracterized the record. She acknowledged that the letter had PAC. She never said, I thought about it. Yes, I put that there.
She never, correct.
Counsel, there's a big difference in how you represent that. And you will also acknowledge that that PAC-C is not a digital signature. Would you agree with that?
It's not a
Her signature, her name, and when you take the mouse over the name in the recommendation letter, the embedded email address says Roma Mirza, student at the college. You would agree that that does that? Would you agree?
That is not, that she did not write that.
That it's in the document
I'm
she
asking
submitted.
you that digital signature that I just described to you, do you agree with what I found in going over the record here?
Her email address.
Her signature on the letter is a digital signature because she used the Casper portal to send these letters out on behalf of her friend to this school, your client, and other schools. That digital signature says Roma Mirza, no PAC next to it. She didn't do it with the flourish like a lot of doctors say MD or a lot of lawyers say Esquire, just bear with me. And it has her email address where if you click it, any reasonable person reading it would see email address saying Mirza student. Do you agree with that?
I did see that, but I would just.
Counsel, what about this? What about on the?
Never argued. It was never mentioned in the Article 78 petition, in her meeting, in her appeal. That was never brought up, so that was not before the court. That
She
was not
didn't have
before
an
the committee.
opportunity to prepare. I mean, really, you take a young person, you put them in a room, you don't tell them why they're being brought there,
Your Honor.
and they are supposed to act as their own counsel on the fly? That's what Mount St. Vincent thinks is fair to their students who pay tuition, by the way?
Your Honor, she had an opportunity to make her, to state her case after the PCRC meeting.
Counsel, what about the opportunities that the school had to look at the information before them? So for example, on the evaluator information portion of the CASPA form, what's listed there? It's listed title, student. It's listed occupation, student. Everything there says student. Nothing there equates to an intent to deceive about qualifications.
Okay,
correct?
so the standard is not whether or not it was intentional or not. The policy itself just says misrepresentation, and she did misrepresent by putting PAC after her name. And it was considered whether each meeting that she was in, each committee considered it. The PCRC said it was a serious violation, even though it was not intentional. The APC also said that it might be a violation of the New York education law, even if not intentional. The provost also explained that misrepresenting credentials of a licensed healthcare provider.
Any criminal activity, just FYI, any criminal case would require an intent to deceive.
But my question to you really is, when you look at this in a holistic way, and you look at the form, you look at the evaluation attachment forms, everything that's there lists her as a student. It's only that one line, that one place where you see this PAC.
That was a determination that these committees made, that was enough to be a violation of the policy and for misrepresentation. And
So my question to you is, okay, why is it, given all of these facts that we have, right, why is it that that determination shouldn't shock the conscience of this court?
Okay, in the standard.
Can I just add, particularly, when she apologized, she said that, she would be more careful going forward. And
if I may respond, it's not.
Oh, I'm not done with my question yet. I have one more thing to say. And, certainly, this is a student with an excellent academic record, and we're going to really, throw up in the air, her future. We're going to destroy her future.
If I may respond, it's not shocking to the conscience because it is contemplated in the policy, specifically in there, that if you misrepresent yourself as a physician's assistant when you're not, that is a violation of the code and can lead to expulsion. It's specific.
Can lead,
and
right?
there are case
Can
law.
lead, right? It can lead to expulsion.
Yes.
So that means that there can be other penalties. Why? And I'm asking you this very directly. Why, with all the other facts that we have, where students listed everywhere else on this paperwork, that it leading to expulsion is not so extreme and harsh that it shocks the conscience?
Because it's contemplated specifically, and she had notice of it, and she's been told of it from the beginning of her studies. And there's case law of very similar situations where people have been expelled for making mistakes and for not fully disclosing for misrepresenting their grades or not fully representing their.
Those are all intentional acts.
Well,
misrepresenting your grades, you intentionally
not
do
fully
that.
providing all the information, that's not necessarily intentional either.
Just one more thing, because you talk about the case law, which really isn't applicable here. We're talking about academic dishonesty, cheating, forging information. That's not what we have here.
It's a sad day when this is how we treat students for making an honest mistake. But we've heard your arguments. You have a minute on rebuttal.
When you talked about dishonesty, Your Honor, Dr. Garofalo dishonestly told his subordinates, none of whom were tenured, by the way, that Roma signed her name with PA after it. That was false. That was a deception. And that followed at every level, also regarding
Can I
fairness.
ask you, how did PAC get there? Because that was the part of the record that I don't understand. How did it get there? How did PAC get there?
We don't know, Your Honor. We believe either she had a template.
Where is that in the record about a template?
I use a template all the time.
I didn't ask you that. Where is that in the record? I didn't, maybe I missed
Well,
it.
how it got
It's in the
there,
record that she
how
doesn't
it got
know.
there is not in the record either, right?
In the record that she does not know how that got there. She assumes it was a use of a template, does not know. Maybe, like I just said, but accidentally I represent the respondent.
Could have been an autocorrect for all we know, right?
The other thing, Your Honor, as bad faith, contract covenants of fair dealing, the agreements, the policies required fairness. It wasn't fair when after the PCRC committee, then they send her an email late at night that she doesn't see until after classes the next day at 5, and then they hold a hearing at 4 and say, oh, we've held a hearing. That's bad faith. Bad faith that the next appeal body is Dr. Galafello, who's probably the accuser, and that the provost received what Dr. Galafello said. You signed PAs with that one she did not.
Thank you.
Lastly, Your Honor, as far as remedy, my client, if the court were, I don't know if you could do it, but if you could almost immediately order her reinstated, she could probably try to resume classes, even though it's 3 weeks in, and then try to survive. But I would request, if the court does do that, you give her an option that if she does not succeed this fall semester, because after that would be clinicals, but if she doesn't succeed this fall, that she'd be allowed to try again then.
You're asking for way too much detail on that relief. Thank you very much. Have a good day.
Thank you, Your Honor.
Eisner versus Pascilico. Pascilico, sorry, I messed that name up. You may proceed.
Your Honors, my name's Lester Channon from Farber, Brox, and Zane. We represent the appellant, Pascilico Civil, which was a general contractor on a project in the High Bridge section of the Bronx, where a 23-year-old iron worker's apprentice claims to have fallen from a 20 to 25-foot ladder in the course of bringing up some equipment.
You would agree that under well-settled appellate case law, even an unwitnessed accident, which apparently this was,
yes,
we have to take the plaintiff at his word that he was on this 20, 25-foot ladder attempting to get over a certain point where it fell off and it wasn't secure and he fell, correct?
I wear hearing aids. I think I got
I'm
everything
sorry.
you asked. But
I'm sorry, I
no,
wasn't
it's
clear.
okay.
Would you agree that the case law supports the principle that you can have an unwitnessed accident and such a plaintiff can meet the burden on a summary judgment record and get summary judgment or partial summary judgment on liability under Labor Law 241? Would you agree?
Yes.
Okay.
Okay.
And is that what happened here?
That's not our view of the case, but yes. Well, that's what the court ruled below. But in any case,
Can I interrupt? Isn't it the standard, I'm just going to follow my colleague, that if a ladder moves in the course of a plaintiff going up the ladder, that meets the prima facie?
Right. That's what we're fighting against, is an allegation by the plaintiff at a deposition unsupported by any evidence.
But there's no the point is, he doesn't have to have corroborating evidence. So unless you have evidence that controverts it, then there's no issue.
We believe that I have a list of 18 inconsistencies, conflicts, and credibility issues.
That has never won the day in this court on this issue, counsel.
Well, Your Honor,
never.
He is claiming that the ladder moved, but it's undisputed that it was tied off at the top.
No, it's not undisputed.
Only on one side.
On one side, according to him.
Why can't it move?
Then there's conflicting evidence that...
What conflicting evidence? I have one person saying it was only tied off on one side, and your people say nothing. Your people say, I think. I think is not enough, counsel.
Our people, his name is Sotnick, who was the senior project manager for Pascilico, testified that the photographs indicate that there was
He wasn't there. He was on vacation.
No.
He has no idea.
Wrong.
Okay. Look.
He was there. He got there 15 minutes after the accident.
Counsel,
and he took
let's
photographs 15 minutes after the accident. And the photographs showed that it was tied, double tied, with a wire that prevented it from moving or shifting.
How many feet up was that wire?
I'm sorry?
How many feet up was that wire that he photographed from the ground?
It was 20 to 25
He said it was,
feet up.
oh, and I'd like to know what camera he used that photographed the wire 25 feet up.
The ladder did not shift. It didn't move. It's undisputed that the
It
ladder
is not
didn't-
undisputed. You have a plaintiff who says he fell because it shifted.
Right.
And you have no one controverting that other than speculation.
He admits that the ladder remained in exactly the same position. He admits that its feet didn't move, although it's a turn.
Counsel, I want to go back to, you said Soknik, right? Is that
Yes.
how you pronounce the name?
I think so.
Okay, because I believe his testimony
Yes.
talks about the ladder sitting on dirt, broken up concrete, gravel that had been created through the construction project. You have give me a moment, please. You have the sketch, the incident sketch form, and that's page 466 in the record, that talks about the ground covered with dirt. Certainly the pictures say it all, where you see this broken up gravel and dirt with the ladder, and you have the plaintiff's testimony. So how, what issue of fact did you raise? Because we know that the ladder was not defective, it shifted. We know what the case law says about, granting summary judgment when that happens. So what was the issue of fact when you have all of this? You have the photos showing that it was on dirt, on gravel. You have Sotnick testifying to the same thing. You have the incident sketch form. So what's the issue of fact?
It was on compacted gravel, which our expert in unrefuted affidavit stated is perfectly secure. It didn't, and plaintiff admitted it didn't move. It's a complete red herring and completely irrelevant. He's talking about the composition of the ground. It doesn't make one bit of difference. It didn't move. So what are we talking about here?
Isn't there a statute that says that you have to place a ladder on a flat and firm surface?
I don't know the exact wording, but I think
dirt gravel would not qualify.
I think there was
his
a slope
testimony
also.
was, and it was unrefuted by the plaintiff, that it was on secure ground and that compacted gravel is in fact a very secure. Well, Your Honors don't believe that, but that is in compliance with the codes and regulations that
You'll have
pertain
time on
to this
rebuttal.
kind of a.
You'll have time on rebuttal. You're out of time.
Okay, thank you.
Your Honors, my name is Scott Singer. I represent the plaintiff respondent. Your Honors alluded to the pictures, and they are very, I think, significant. They are on 456, 457.
Is there any direct evidence with respect to the ladder being properly tied off? Not just on one side, but properly tied off throughout?
There's no evidence that it was tied off. And I just wanted to point out.
And was there any evidence that contradicted your client's statement that the ladder shifted, causing him to fall?
There was no evidence of that sort. And if you look at the photograph, not only was it on gravel, but it was a very steep slope. You can see that on the picture on 457. And then, by the way, by contrast, and I cited it in my papers, but I didn't discuss it in any length. At page 683 in volume 2, you see a ladder. This was taken months before the accident. A ladder on a board, on a flat surface, properly placed so that it was stable. This was on a slope. It was on gravel. It didn't have to be done that way.
Mr. Singer, I'm sorry. Mr. Singer, they claim that the plaintiff, your client, was the sole proximate cause of his accident because he was carrying burn blankets and he didn't exercise the three-point contact with the ladder. Is there any evidence of that in this record?
There's no evidence of that whatsoever. But what he did say was that he had a belt on and there was a pocket in the belt where he put a vest in that he was supposed to bring up.
And a
there was
tool in the other
And a
one.
wrench.
the other side, and that's
He was ascending the ladder to bring a worker, an iron worker, up on the platform, a wrench and this vest.
right, and he was
And he specifically denied in the papers that he was carrying a burn blanket.
That's correct. And if you look at the pictures, they were underneath him. He explained that somebody put them underneath him because he fell 20 feet and he was terribly injured, which makes sense. There's no the statements that they referred to were not contradictory to his testimony, and they were made by people that apparently had no knowledge, direct or indirect, about what happened, because the two people that were there, Mr. Sotnick and Mr. Orso, didn't speak to him. He was
Counsel,
in terrible shape, and they
did
didn't.
Mr. Sotnick climb up the ladder, given that he said that it was tied off? Did he
I
go
don't
up there
believe
himself?
I don't believe he climbed up. No,
Okay.
that's not my recollection. And I don't think he did anything to check the conditions of the ladder. And I know that he said, I couldn't speak to him. He was in bad shape. He was knocked out. He wasn't going to discuss it with him. So, and the whole burn blanket issue was there's nothing there to support it. For those reasons, we believe there was no dispute. Also, there was very clear violations of two regulations. One was 23-1.21, which requires that it's supposed to be secured, completely secured, and 23-1.7F, which requires a stairway. This is not a situation, a one-off, somebody put up a ladder. This is the way people got up to the top, and it was not in conformance with the regulations, and it was not in conformance with Labor Law 240.
Thank you.
Thank you very much, Your Honors.
Your Honors, we have on our side, an affidavit from an expert saying it was safe, the compacted gravel was safe, and on the other side, we have people speculating about what is or isn't safe without any expert testimony. It's amazing how you can come to these conclusions.
Although it seems to me the more important thing is that the ladder wasn't tied off. A ladder that extends 25 feet is not tied off on both sides?
Well, Your Honor is coming to a conclusion about whether it had to be tied off on both sides rather than one side. First of all, Sotnick testified that it was tied off in the center and may have been tied off on either side. Setting that aside...
Did he go up the ladder? Did he go up the ladder?
No.
He didn't go up the ladder, as far as I know. But the plaintiff didn't know, did the ladder go to the left? Did it go to the right? He couldn't say that. He did it, how far did it rear back? His testimony was so incredibly vague. And Your Honor's...
Because, when I'm falling off a 20-foot ladder, I'm measuring how many feet the ladder is shifting, counsel, please. That argument is kind of ridiculous, right? It's just not the human experience. Even when you're falling on a sidewalk, you're not measuring how many inches am I away from the curb. That's not the way the human body and the way the human mind experiences these kind of
He didn't know how the ladder could have moved. He didn't give
Does he
any
have to
explanation
know?
for...
Does he have to know how the ladder moved?
He doesn't have to know anything, but there's a mountain of evidence that indicates it couldn't have moved, and it didn't move. So I don't know how we can come to the conclusion other than maybe a few inches. This guy was a lifelong karate practitioner. He was on his high school
Counsel,
karate,
please.
his
What does
wrestling
his
team.
being a karate whatever have to do with falling off a ladder?
Well, how
Thank
could
you
you-
and have a good day.
Okay, thank
On
you.
that
Ellen.
note. People be Stephen McKinnon. I'm messing this name up, and forgive me. Could you please say it to me again?
Yes, Your Honor. May it please the court, Lawrence LeBrew for Mr. Stephen McElnany.
McElnany. Thank you. And please, you may proceed, sir.
Thank you, Your Honor. On behalf of Mr. McElnany, we're asking that this matter be reversed because Mr. McElnany's plea was an annoying, intelligent, voluntary plea because he didn't receive constitutional effective assistance of counsel. We made that
Did he file a 440 motion to that regard?
No, Your Honor.
Are the facts regarding whether he received effective assistance ascertainable from the record?
Yes, Your Honor, he filed a motion to withdraw his plea before sentence was entered, and that issue was raised in that motion.
Yes, but that doesn't go to the issue of why your client believes that his counsel was ineffective prior to the entry of the plea. So the fact that does the record bear out, typically in a 440, it affords the counsel that's being complained of an opportunity to explain why they did what they did and what course of action they took legally on behalf of their client. So the question is, do we have enough on this record, just on the basis of that motion, without the benefit of counsel's response to why he did what he did, sufficient for us to assess this, this claim?
On behalf of Mr. McKinnon, we think the court has enough, but ultimately the court will make that determination if there's enough and if this claim has merit. But we think we have enough on the record to demonstrate that just by the lower court record that's before this court. And I can proceed to elucidate that a little bit further.
Please do.
Okay, this case started out, it commenced in March 9th of 2022. And one of the important things that one can look at, this court can look at when you're trying to make that determination, you can start with the indictment. The indictment charges conduct from 2012 to 2018 and one count in an indictment, okay? Now, in this situation, everybody agrees that the defense counsel never got the grand jury minutes, okay? And the record shows that we submitted...
He tried to get them, and the court would not provide them on basis of safety of the people who had testified in the grand jury.
Well, that's not. Our position is trying to get something in the lower court means that you don't just ask, you take some type of judicial action, meaning that if you reach out and you don't get it, then you file a motion and you let a decision be made. Okay. And if you still don't get it, then you file another motion and let a decision be made. And given the change in the discovery law, which revolutionized discovery, especially in New York City in 2020, the grand jury minutes are essential for any case, especially...
Right, unless there's a protective order in place that precludes the defense from having a copy until a certain time, right?
There was a protective order in place, and the court raises a good point when you bring that up about that protective order. Our reading of that protective order, as it is written, does not prohibit the defendant from getting the grand jury minutes. As the court stated, the protective order says certain information about certain witnesses will not be disclosed, but that order does not say you cannot have the grand jury minutes. Okay, so once you get that order, our position is once you get that order, and there's some ambiguity there, you have an obligation to press that forward, especially when you're dealing with a one indictment case, okay, where the crimes are alleged to have occurred over 7 years, okay, and in the indictment in and of itself, given that time period, there's automatically a couple issues that come up on its face. First, when did the crime happen? Because
it's a business, and an argument could be made because your essential claim is that there was ineffective, I'm sorry.
Go ahead.
That ineffective assistance of counsel because he failed to raise statute of limitations. That's pretty much what you're raising. And there's a real possibility that that would not have made a valid argument because one can view that whole prostitution business during that whole period as an ongoing business. So, which means that when they were charged in 2022, it's within the statute of limitations, correct?
That is 100%.
And that's what my colleagues raised to you, that in the absence of a formal 440-10 motion to bring that attorney back and go through his thought processes, we'll never really know whether there was really ineffective assistance of counsel or a legitimate strategy, correct?
Well, I agree with the court in one aspect of that, as far as the 440 motion fleshing it out. And the other aspect of that, you're correct. It could have been a continuing business. It could have been they were running the business from 2012 to 2018. But as the defense attorney, the first thing you want to know is, I want to see the grand jury minutes to see what evidence went into the grand jury so I can make a determination as to what it was.
Okay, you'll have time on rebuttal, but as I said earlier, the attorney did seek copies of the grand jury minutes, and the court declined to provide them for reasons, and instead issued a protective order to protect the women who testified against this defendant. But you'll have time on rebuttal.
Thank
okay?
you, Your Honor.
You may proceed.
Good afternoon, Your Honors, and may it please the court. Addison Esley for the people. As Your Honors had pointed out correctly, there was no 440 motion filed in this case, so we can't adequately assess defendant's current ineffective assistance of counsel claims. With respect to the grand jury minutes, I want to push back on this notion that Mr. Southard below did nothing to secure the grand jury minutes. He did. When he was first retained on this case, that protective order was already in place, and he reopened that issue and got a hearing and fully litigated that. Why he chose not to then take some sort of interlocutory appeal on that, again, as Your Honors mentioned, goes to his mindset, which we can't.
Counsel, how do you respond to your adversary's point that that protective order was vague and that required defense counsel to do more to have a real understanding of what was included in the protective order in terms of the grand jury minutes?
The understanding below, Your Honor, was that this protective order did apply to the grand jury minutes. After the protective order was issued, defense counsel re-raised the issue of the grand jury minutes at multiple appearances thereafter, before the people ultimately said, we are not providing these grand jury minutes because they are covered by the protective order. Then counsel did not proceed to appeal that in any way. And there was just this general understanding below that the protective order did apply to the grand jury minutes. So the notion now that that protective order was too vague to have been interpreted as covering the grand jury minutes is just unsupported by the record, Your Honor. And I also want to say that with respect to Mr. McEnany's sort of information on the charges and what was going on in the grand jury proceedings, the people did provide 2 terabytes of discovery to Mr. Southard in the form of hundreds of thousands of emails. We gave bank records, all this. So this idea that Mr. McEnany had no idea of the date range or anything to that effect is also just not supported by the record.
Those emails and bank records would have corresponded with dates of when the alleged conduct was to have occurred?
That's correct, Your Honor. Yeah, the bank records and the emails show that all these actions for which defendant was indicted did correspond with the dates on the indictment. Just going off of the emails, one does not need the grand jury minutes in order to fully comprehend what was going on in this case. The people provided defendant with ample discovery here. And I also want to point out that defendant does not in any way challenge the plea colloquy itself. The plea colloquy did establish a knowing, voluntary, and intelligent waiver here, or guilty plea rather. And if Your Honors have no further questions, the people ask that you affirm.
Thank you.
Thank you.
You have a minute, and I'll give you his extra 15 that he left behind.
Thank you, Your Honor. Okay, our position with regard to the grand jury minutes is a defense attorney at a threshold level should not assume that there's an order saying that you can't have the grand jury minutes, okay?
He didn't have to assume, he had an actual order.
The order, and you have the order, and I'm not going to debate the order. The court can look at the order. The order speaks for itself. So I'm not going to debate the order. I'm just going to say this. If you don't have the grand jury minutes and you don't like the order, okay, the first move is to go back to the judge and to re-argue and let him deny it for whatever reason. If while that's going on, if you don't like that, then there's a provision in the statute where you can come here, okay, because you have an issue with a protective order and et cetera as to what took place and what was done. When you're dealing with a one-count indictment covering about 7 years, okay, and you're arrested 4 years later, You want the grand jury minutes, okay, so that you know what's
Counsel,
going
what
on.
about the other discovery? Did the other discovery not, enlighten defense counsel on the date time range?
The discovery was beneficial in the sense that it gives broad parameters, but the grand jury minutes provide the evidentiary basis for the charges, and then the discovery fills in the blanks. You need the grand jury minutes because none of that discovery might even come in at trial. You want to know, in order to put on the defense, who came into the grand jury to the extent that you can, and who said what, so that you know how to proceed.
And therein lies the rub, which is why the court issued the protective order. Thank you.
Okay.
People v. Jose Matias.
Good afternoon, Your Honors. J.M. Baselli on behalf of Mr. Jose Matias. Wanting Mr. Matias to admit direct involvement in the crime, his ADA interrogator made him a promise at minute 22 of their second interrogation that implicated Mr. Matias's fundamental constitutional rights, was a promise that any ADA would know not to make lightly, and was a promise that under any interpretation, she broke to Mr. Matias's detriment. The ADA unequivocally promised him, I'm not going to tell anybody about this conversation that we had, and neither is the detective who happened to be sitting beside her. Afterwards, for the first time, Mr. Matias corroborated that.
So let me start by saying, I don't like what the ADA did here. But the issue is not whether I should like it or not, it's whether it's legal or not, right?
Right, Your Honor.
And so clearly case law is replete with cases that say that the police are certainly entitled to lie to a defendant to try to get them to confess.
Right.
Is there the same prohibition against prosecutors?
Indisputably, Your Honor, on two different bases. One, we have the rules of professional conduct that we all practice under, which specifically prohibit attorneys from engaging in fraud, deceit, exactly as in there, or misrepresentation, coupled with the duty to be honest.
So let's talk about that. You said, the prosecutor said, I'm not going to tell anybody, right? So
about this conversation.
About this conversation. All right. Now, is that necessarily a lie? Hear me out. You and I both know that if the prosecutor had to prosecute the person that he was talking about, he's going to have to take the stand and say what he said. But that's not the prosecutor saying what he said. So the prosecutor is not lying. The prosecutor is not saying it. The prosecutor is going to make him say it. How is that a lie?
Well, Your Honor,
she may have deceived him. She was playing word games, right?
Sure.
But did she lie?
She did, Your Honor, because
she wasn't gonna, in a courtroom, say, he told me X, Y, and Z.
No.
She was gonna put him on the stand and say, what did you say?
Your Honor, her promise would have been meaningless to him if she had meant these statements are going to leave the room. And case law in New York State happens to be vanishingly rare on this subject because
But doesn't the record here show that he knew that wasn't the case?
I don't
He said to the detective, ain't this being recorded? So he knew that what he was saying in that room was being recorded and could be used later. He said it.
Your Honor, I don't believe his awareness gets him there. He knew his awareness, or excuse me, he had his awareness that the conversation was being preserved. But again, her promise wouldn't have meant anything to him because these recordings don't have legs. They don't walk themselves into court. If the ADA, the spokesperson for the people's investigation, says to an interrogee, I'm not going to tell anyone about this, presumably she has authority to keep the recordings private in conformity with her promise.
But she didn't say, I'm going to keep the recordings private. She said, I'm not going to tell anybody about our conversation.
Right, Your Honor.
Again, I get it.
Yeah.
Mincing words. I get it. But is there a real violation in light of how she carefully danced around this? And on top of that, let me throw into the mix.
Sure.
This guy was he was quite experienced in this.
Your Honor, he was
I don't want to say it out loud. Quite experienced in this.
well.
Right?
So, Your Honor, if I may, again, being just a circumspect, this was not a contract. This was a unilateral promise made by a prosecutor that didn't require any further action from him to take effect. And every other state Supreme Court, and we cite them on pages 19 and 21 of our brief, every single state Supreme Court to look at a promise like this has found that it's a blanket promise of confidentiality and that no interrogee would know the difference between
The
that.
legal analysis, counsel, is whether in fact his will was so overborne such that this was not a knowing and voluntary waiver of his rights.
Your Honor, that's one species of involuntariness, but as the Supreme Court said in Rogers versus Richmond, the prohibition constitutionally against involuntary statements is because the method used to extract them. May I finish, Your Honor?
Yes, please.
Violates a principle of justice. And the Court of Appeals in 1918 in People versus Riley talked about when a prosecutor makes a promise, which here was in effect, that I'm not going to use your statements against you, she has a duty to keep it, or else the statement's involuntary and must be suppressed as fundamentally unfair. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. ADA Ethan Solomon for the people. I want to start by agreeing with you, Your Honor. I don't particularly love what the ADA in this case did either. But
I'm glad to hear you say that, so I don't want to see it again, okay? Go ahead.
but the question, as Your Honor noted, is not whether the ADA below acted entirely correctly. The question is whether defendant's will was so overborne that these statements needed to be suppressed. And within the context of the conversation that he...
Especially where here, the defendant seemed to be primarily concerned with the safety of his family. And either the prosecutor's statements are true or the prosecutor didn't give a damn.
Well, Your Honor, I think you're absolutely correct that defendant was primarily concerned with retaliation by his accomplice, and that this was the pattern that repeated throughout both his conversation with the detective and his conversation with the ADA. They wanted information about his accomplice. First it was his name, then it was whether he had a weapon, information about his accomplice, not really about defendant. And defendant was reluctant because he was concerned. And so they reassured defendant. In essence, not, we're not going to use this against you. Nothing that would vitiate the Miranda warning. Nothing that would make defendant believe that his statements weren't going to be used against him in court, but that they were going to try not to let these things get back to his accomplice.
But they didn't say that, right? They said, no, we're not going to repeat this to anybody. Anybody includes the courtroom. No?
Within the context of this conversation, just like in Weaver, which we think is a case that is fairly closely on point here, when the reassurances follow on the heels of defendants' concerns about potential retaliation, they have to be viewed in that context, and you can't just isolate the words and take them purely standing on their own. But even if this court finds that the statements that defendant made after this minute 22 exchange should have been suppressed, his guilty plea can still stand in light of the rest of the evidence that the people had in this case. The plea can stand as long as the statements that he made after this exchange didn't contribute to his decision to plead guilty. And where, in this case, the people have the witness identifications, his previous statements before this minute 22 exchange, where he admits to being on the same floor, he admits to being with his accomplice, he has the injuries on his face, you have his wife, his estranged wife, I believe, coming into the precinct and saying that he was involved. There's ample evidence in this case that would lead a reasonable defendant
That's probably the strongest argument you got right there.
to decide that he should plead guilty.
His wife comes in and hands him to the police. So, I mean, seems to me that's your strongest argument here, that even if all the other.
We don't want to concede the issue about the exchange, but yes, if.
Okay.
Even if.
Thank you.
Your Honors.
Your Honor, let me jump right to the harmlessness point then, because this is a one ID, a saleable ID case from a complainant who said she was only somewhat sure in the photo array. And regarding the statements from Mr. Matias' wife, she didn't say, my husband was involved. She said, I heard he was involved in an altercation. That's a hearsay statement of unknown origin. We have no reason to think it'd be admissible. This is a prosecution that lasted 2 years. We knew from the jump it was one ID, no video, no DNA putting him there. He was waiting to see if these statements were gonna come in. The suppression hearing decision came down in September 2019. He pled the very next court date in October. So there is no reasonable possibility that the denial of suppression here did not affect his decision to plead, which is the standard. But I also wanna just recontextualize Weaver here. The Weaver case is not on point. The Weaver defendant freely admitted his role in that shooting before any promise of confidentiality was made. And differently here, Mr. Matias steadfastly refused to put himself on that 13th floor. I wasn't in front of that door, I wasn't on the floor. However, right at the moment as the prosecutor says, were you the one who supplied the masks? Were you the one wearing them? Were you the one with Umar? She makes her promise of confidentiality right at the time that was precisely meant to elicit an incriminating statement. That is the lie that she thought he was telling, that I wasn't there, but Umar was. So even if he was afraid of Umar, I think Your Honor should consider the Nebraska Supreme Court's decision in Nash, and I'll close with this. The officer in Nash assured the defendant, the conversation we're having in this building is gonna stay here. The Nebraska Supreme Court determined that even if that promise was motivated by Nash's fear for his safety, if his accomplice had realized he turned an informant, it had broader implications that would cause a reasonable person to believe his statements would not be used against him. And I think, Your Honor, when the prosecutor says, I'm not gonna tell anybody about this, the effect is just the same. Thank you, Your Honors.
Thank you. Emissions reduction versus Mloud Technologies.
Good afternoon, Your Honors. Amanda Laurel Gayer for the Appellate Emissions Reduction Corp., or ERC for short. This is a case about 3 bad actors who fabricated a universe of alternate facts to induce a loan that their company would have needed in order to sustain and grow its business. They then took that money and siphoned it out and used it for, among other things, their own executive compensation. And they are now hiding behind the company and arguing that they're not liable for this fraud. The trial court...
Is that what they're arguing, or they're not arguing that since this is a contract claim, the damages are as it relates to breach of contract, and so because of that, the fraud claim is duplicative?
Well, the fraud claim can't be duplicative as to individual non-signatories to the contract.
Are the damages not the same?
Well, they're not the same.
They are the same. You're seeking the compensation that they received, correct?
There are components of the damages, like the principal of the loan, and I mean, depending on if you're under contract or fraud, there would be default.
Because the allegation was that they took part of this, certainly the first $5 million, they took part of that and paid money to their executives, which are the 3 named individuals here, correct?
Correct.
So that the breach of contract claim encompasses that $5 million. Yes?
The breach of contract claim, those $5 million would be recoverable against the company.
Yes, you don't get to double dip. So if you get the $5 million from the company, then you can't also get the same monies from the individuals.
Certainly.
So that's duplicative.
Certainly, we're not seeking double recovery, but
So then the breach of contract claim covers those damages, and the fraud claims are duplicative of the breach of contract because the damages are the same.
there is,
And I'm looking at paragraphs 98, 103, and 111 of the amended complaint, and they all seek to recover the $15 million outstanding principal balance of the note. I'm looking at paragraphs 98, 103, and 111 in the amended complaint.
no, so in the fraud claim, we're also seeking to recover other out-of-pocket expenses under a fraud theory, such as the harm to the company's valuation, liquidity, and loss of investors.
That is not a pecuniary loss, correct?
We're also seeking auditing costs, costs of.
All of that would be included in the contract claim.
The contract has a provision that limits certain damages components to a certain threshold or cap. And where a contract caps damages, courts hold that the plaintiff is free to go through discovery and explore the extent of damages under both theories, because where there is a cap on damages and there is not in fraud, they're not necessarily the same.
I just want to go back.
I just need to understand, though, what damages you're claiming in fraud with respect to the three individual defendants. Is it not the compensation they received from the the first $5 million advance?
We're seeking our out-of-pocket losses.
With respect to these three individual directors, is the damages you're seeking from them to recoup the money given to them from the $5 million? Am I right about that?
We're seeking to recoup the money that we spent out of pocket. It doesn't matter where it went in terms of our damages. The money that ERC paid out to this company, which
the company
paid out to the company, that was the loan money, right?
The advances, which were fraudulently induced.
Right, but that's all a part of what was covered by the contract in terms of what you contracted with the defendants for.
We don't disagree with you that there's a clear breach of contract claim here. No question about it, okay? The issue is whether there is a separate fraud claim that can be sustained, which is not duplicative of the contract claim, and I don't see it.
Well, this department has held that way in Allenby, Subaki, Weil.
I was on MBAI, and based on that case, this is duplicative. So I'm going based on my case, okay?
But all of these courts have held that even where the same damages are recoverable on contract and fraud.
MBAI has not been overturned. So explain to me why I should not follow my own case.
I'm sorry, which?
MBAI.
MBIA?
MBAIA, sorry.
There are a couple MBIAs.
Forgive me, MBIA, Insurance Company, 165 AD 3D.
Okay.
108. Where we mandated dismissal of the fraud claims since the claimed fraud claims and damage and claimed contract damages were identical in means of calculation and amount.
I don't believe that case involved claims against non-signatories. So we did not pursue our fraud claims on appeal against the company because that really, muddies the water. Whereas with respect to individual non-signatory defendants against whom a fraud claim is not viable, again, this court has held in Allenby, Subaki, and Weil that we're free to pursue different parties under different theories, even if the damages overlap.
Thank you.
And
you'll have time on rebuttal.
Sure.
You may proceed.
Good afternoon. May it please the court, my name is John Elliott, excuse me, with the law firm of Sickenzia, Ross, Ference, Carmel. I'm here on behalf of the individual corporate defendants, Mr. McMeekin, the CEO, Mr. Lanza, the Chief Growth and Revenue Officer, and Mr. Poe, the executive vice president. As the trial court properly held, the fraud claims are duplicative of the breach of contract claim because the damages are exactly the same. We saw in the briefs that plaintiff has argued that the damages are not identical because there is a cap. Supposedly in the contract, it's not a cap. It's a $20,000, up to a $20,000 limit for just the preparation, negotiation, execution, and delivery of the loan documents. But they can seek fees above $20,000, and borrower will not unreasonably withhold consent thereto. So if they can prove at trial that they expended over $20,000, those fees would be reasonable, and they would be entitled to them under the contract.
Also, these corporate defendants, they lied in order to get this loan money and then lied about what they were using the money for. Why is that? Why can that not be considered fraud?
Falsity
and inducement.
The allegations are that that's what's alleged. But at the end of the day, they were speaking in their corporate capacity on behalf of the company, and they were not seeking to obtain personal benefits from it.
But they did receive a personal benefit.
Personal benefit,
by getting some of the cash from the $5 million first payment that was intended not for that purpose. So they did receive a personal gain from it.
The only personal benefit that was alleged in the complaint was that they received their salary. That's all.
If they weren't receiving their salary before the infusion of cash, if the only way they received their salary was because of the infusion of cash, which was promised not to be used for that purpose, no go.
Well, courts have held that the use of salary for
Counsel, you're really going to argue that? You're going to argue that it was okay for them to lie and say, we need this $5 million in order to set up EV stations for New York dealerships, et cetera, and oh, by the way, we need another $10 million to finish the job when they had done nothing and instead paid themselves? That's your argument? Come on.
Your Honor, the use of proceeds provision in the contract itself allows them to spend the funds on business, not just the development of
the contract they had was very specific on what they could spend the money on, and it wasn't on their own salaries.
It says on section 7.9, use of proceeds of the loan solely for the development and deployment of borrower's building energy management business.
That doesn't equal, so pay yourself so that you could do this. That's not what that section says.
It's not explicit.
No, it's very explicit. You are to spend it just on this project.
Well, I think that the respondents believe that business, by saying that they could spend the money on the development and deployment of the business, would include business paying themselves. I mean,
Good luck with that.
They're not expected to work for free.
Good luck with that in front of a jury, but go ahead. Go ahead.
Well, regardless, the point is the damages are identical. That's the bottom line. That's what the trial court found, and that remains the same on appeal right now. Thank you, Your Honor.
Thank you. Counsel?
I'd first like to respond on the damages piece. Damages, again, where the contract contains certain limitations upon the damages that are recoverable and has a cap and uses the term reasonable, that's something that is a fact issue that needs to be, this is a motion to dismiss. This is something that needs to be explored through discovery to ascertain whether the damages are or are not the same. But in any event, as I was mentioning earlier,
Counsel, why can't we look at the complaint to see what damages are alleged in the complaint and make a determination as to whether they're the same?
Because the exact amount of costs and expenses occurred and losses is not alleged in the complaint. It's to be determined during discovery. And so, and also in terms of
But that can't be a basis for us to not evaluate whether this fraud claim is duplicative or not. I mean, we have these cases all the time, and all of the extent of the damages is not known early on. That is not a basis for us to not dismiss where otherwise we see that the claims are duplicative.
Well, the fact that these are against individual defendants, like for example, in the Court of Appeals decision DDJ, which did not involve a claim against, the borrower was defunct and they chose not to bring a contract claim there. But it was very clear that the loan was for $40 million. It would have been recoverable $40 million against the borrower. That same amount was recoverable in fraud. And you see the same result in case AABCO, ABCO. Again, there the damages were identical. And there was a fraud claim against non-signatories and a breach claim against the company. Both were viable.
I agree, there's cases all over the place. We will sort through them and figure this out. Thank you.
Thank you.
Okay. McCraine, Mungo versus Dag Hammarskjold Tower. You may proceed.
Good afternoon, Your Honors. May it please the court. I'm Jason Fixler on behalf of defendants here. The issue before the court today is whether a defendant has carried its burden of entitlement to summary judgment by submitting plaintiff's own photographs in admissible form properly authenticated through plaintiff's own exchange during the course of discovery, where the photographs contain measurements taken and data recorded by a representative of plaintiff. During the course of discovery in this matter, Your Honors, plaintiff exchanged several photographs. Those photographs were presented to plaintiff and authenticated by her at the time of her deposition. She confirmed at her deposition that she was there, she watched the pictures being taken. It was a representative of plaintiff's office that took the photographs, that measured the areas. Pursuant to 4540, those were authenticated. I used those in the course of a summary judgment motion, and in opposition to that, plaintiff did not adequately rebut that prima facie showing.
Well, sure they did. We have a situation where you claim, based on your record, that the gap, and I'll use that just as an expression.
I'm sorry, Your Honor.
The gap between where she claimed she tripped.
Well, I'm glad you brought that up, Your Honor, and I'm assuming that you're saying that they adequately rebutted it through their proffer of an expert.
Yes.
Okay. Well, let's talk about that for a second. And I'm very glad that you brought that up because that really is the linchpin here, right? So plaintiff proffers the pictures originally. The pictures aren't good for them. So they bring in an expert to actually say, hey, look over here. Don't look over here. That expert did not adequately rebut because that expert did a couple things. One, it did not actually address those photographs in any way. That wasn't included in the affidavit. That wasn't included in any way in their
You wanted the expert?
The expert did not.
Can I finish my sentence?
Oh, Your Honor, yes, of course.
Okay. You wanted the expert to address the plaintiff's pictures?
It's the plaintiff's expert, and he's...
The plaintiff's expert took his own picture, right?
Correct, Your Honor.
Okay, and he explained what he believed his photographs showed, correct?
Sure,
and so what's wrong with that?
Plenty, actually. In the first place, he has to actually adequately rebut the showing of the pictures that she pointed out.
Why does he have to rebut it if he thinks that there's nothing to rebut? He's explaining it.
Well, in the first place...
He's an expert, she's not. She's a layperson.
It's not about her. It's about her pointing to the exact location of her accident.
Why can't we have multiple pictures and at trial the jury will find this picture versus that picture? Why is one better than the other?
Because one was authenticated by the plaintiff and one was not. Plaintiff didn't actually show a point in these pictures that this guy used. He went there sight unseen and picked a spot. But let's talk about the expert.
I thought we have a picture of her bending down, pointing to it.
Yes, but she was there for the ones that were measured, the ones measured by plaintiff. Now, but let's assume that we're going to use this expert. Plaintiff in this case was walking southerly. The expert, actually, his affidavit established that this constituted a tripping hazard specifically for someone walking northerly. It is in his affidavit. So he says the pitch, the level, which incidentally was less than a half an inch, okay, 7/16, I believe, at the most.
His says more.
Correct.
So
I'm sorry?
the experts has a different measurement.
Yes,
So
and
there is a discrepancy between the two measurements.
Correct, but his specific affidavit testimony, if you will, is in fact that this defect caused a toe-grabbing defect for someone walking northerly. He never addresses what it does for someone walking southerly, and plaintiff specifically denies the fact that she actually had her toe grab against the defect. So the manner, so his own matter of rebuttal actually does not address the facts and circumstances before this court.
Isn't that again for the jury to decide which direction the plaintiff was walking?
No, because he'd be precluded at trial from testifying about anybody walking southerly because his 3101 is northerly.
The testimony comes from the witness, not from the expert. So if at trial, we're talking about a trial, you just said.
Right, but at trial, he'd be precluded from offering any evidence concerning someone walking southerly because his 3101
You're not
explicitly
understanding
says
what I'm
northerly.
saying. I'm saying that let's assume, for argument's sake, that the plaintiff gets up and testifies X. And then, whether it's north or south, you can use that. But right now, there is testimony from the plaintiff, and the jury will decide if she was walking north or south. There's no issue of fact that was determined as to where she was walking.
No. It's dispositive that she was walking southerly, 100%. But the point is that the expert himself, when he offered an opinion as to the nature of the defect, he opined that the nature of the defect was one for someone walking northerly, not southerly.
Thank you. You'll have time on rebuttal.
Good afternoon, and may it please the court, Kayla Bargeron on behalf of the plaintiff respondent. This case is very simple, but it's very murky because there are some inaccurate facts being thrown around. So from the simple basis, the defendant loses no matter how you parse through the facts. Because either the one photograph on record page 360 with the white ruler actually shows 7/16 of an inch, which is 1/16 of an inch below a violation of the administrative code. And that was it. If it's admissible, fine. Then plaintiff made a material issue of fact in opposition by putting forth an expert that provides a measurement that actually shows the violation of the administrative code, and the law on this issue is painstakingly clear. If there's even a scintilla of a possibility of a violation of administrative code, summary judgment has to be
Did the
denied.
plaintiff authenticate the second pictures that the engineer took? Because counsel said it was not done.
So this is the murky area. So parsing out the knowledge that I have from being personally working at the firm and just sticking to what is actually in this record, plaintiff does not authenticate the photograph of this alleged 7/16 of an inch with the white ruler.
I'm talking about the second picture.
The expert's report says the first picture in my report is the plaintiff actually pointing at the defect. The plaintiff says, I went with somebody from plaintiff's attorney's office or that they told me to go with, and I know that they took measurements, but I didn't really watch them take any measurements, or I didn't watch them take all the measurements. I'm not really sure. I sat in the car for part of it, okay? We don't know if the plaintiff went with our expert. He took photographs. He's somebody from my office or that my office hired in order to take photographs. He put a photograph in his report of her pointing at the defect, which clearly indicates that she was at the location. His report doesn't say if she went with him. It doesn't say she didn't go with him. She was never questioned on whether she went with an engineer or a paralegal. I don't know.
The photograph submitted by the expert includes a photograph of your client in it.
Correct.
Okay.
Okay.
Pointing to the spot.
Correct. And then the defect that he measures is the spot she's pointing to in the first photograph. Now,
Which is the one that's measured at 1/2 an inch would violate the code.
correct. And then he also says that if you go along the expansion joint of the sidewalk flag, there's other areas that are actually higher than 1/2 inch. But you don't need to measure the whole joint. You only need one part of the subject joint to be 1/2 an inch or higher. Otherwise, it's a violation. So I don't know who went there with this white ruler, which was clearly not our expert because he used a yellow ruler and stuck it at what point of the sidewalk and got something that counsel is interpreting as 7/16 of an inch. Because if I look at that picture, I mean, I would have said 1/2 an inch, but I mean,
looking at it really carefully, I guess I could parse out a 1/16 inch less, but if
Can
we
you tell
move,
me, where did that photo come from? Wasn't it from the plaintiff? The first photo?
my office exchanged it, but there's nothing in this record that shows where it came from, who took it, or anything of that nature. And counsel's respondents.
But you provided it in discovery, right?
We did, but there's
So
nothing.
you can't step away from it now, right?
Not exactly. We don't need to step away from it because the point is it wouldn't actually come in at trial with the information that's presently in this record because the provision of the CPLR that's cited in the reply.
Oh, that could come in as something that had been disclosed. No question about it.
Potentially, but it doesn't make it admissible because CPLR 45.
If I say it would come in, it means it would be admitted. That's what I mean when I say it would come in.
What I'm saying is it could potentially come in because CPLR 4540 requires things that come in to have actually been generated by a party. Nobody asked.
Counsel, again, to me, this argument is meaningless because at the end of the day, you provided it. And as my colleague said, you're not going to be able to walk away from it.
Right, and I don't think...
But I don't think that's the issue.
Exactly,
Okay?
and I don't think that's the problem either because that's like looking at if I can prove my case at trial, and that's not the standard here. The standard here is we have this picture with the white ruler. We don't really know where it came from. Counsel reads it as 7/16 of an inch. I don't know if my expert would stand up there at trial, look at the white ruler and say, no, I actually read that as half an inch. Like, who knows? That's not the point. I have an expert that said it violates the administrative code. The defendant didn't even utilize an expert, but moving really briefly to the point about the wrong direction in the expert report. Plaintiff was walking south. That is an error. Our expert made an error. There's also an error in the last part of our brief. She did not strike her toe on a raised piece of sidewalk. What she testified to was very clear, and what we recited in our factual recitation was very clear and consistent with her testimony. As she was walking, she placed her right foot down. There was a misleveled piece of sidewalk under her foot near to her heel, okay? Our experts stated on pages 598 and 599 that a height differential in the sidewalk of half an inch or more could cause someone to strike their toe, or it could cause the raised and uneven surface for a person's foot to become entrapped and directed towards the exposed edge. So he's not only saying, like, this defect is a problem if she's walking one direction or the other. He makes an error in the direction she's walking, but it's immaterial because all that needs to happen to defeat defendant's summary judgment motion is to establish that there's a potential violation of the administrative code. The cause comes from the plaintiff.
Okay.
Thank you.
Thank you. You have 1 minute.
And just to address this, I mean, obviously we've gone through the area of authentication and the admissibility of the actual photograph, but that's enough here. And when you're actually talking about an expert who counsel admitted actually got it wrong in the record, and they said the foot getting entrapped towards the exposed edge. Towards the exposed edge is walking northerly. The exposed edge is above the lower one, whether it be 7/16 of an inch or a half an inch. The court is, so as far as the expert goes, the expert has basically taken himself out of the game by getting the facts wrong, as counsel admitted here.
I think that's that'll be a subject of cross-examination, and your side will have a lot of fun with that, right?
But Your Honor, I would disagree because when they're talking about the nature of the defect itself, the nature of the defect is the nature of the defect. And you, Your Honor, in Weatherspoon and in Powell, both found that measurements were enough on photographs. These are pictures that were provided by plaintiff's counsel. Those measurements actually are the measurements of the case.
You have two separate, different measurements, okay? So we cannot resolve that as a matter of law. Thank you.
But both provided
Thank
by plaintiff,
you.
Your Honor.
Thank you. Delusen versus Equinox.
It's been a day.
Yes, it's a long day. How are you?
I'm good. Good afternoon. Now for something a little different. My name is Evie Kazansky. I represent Woodway Treadmills, and we're here today to talk about an alleged defective treadmill. So very quickly, the plaintiff filed a suit with the allegation that on July 11th, 2021, that a Woodway 4Runner that had been at an Equinox on East 54th Street spontaneously accelerated. And we claim and we state that there are only really two causes of this accident. One, the plaintiff's misuse, and two, Equinox's placement, which Equinox does not deny caused a portion of the plaintiff. The manufacturing defect, this was the 32,000th Woodway treadmill of the Forerunners since 2012. It was purchased by Equinox in 2015.
So really the issues here are, did Equinox contact Woodway and say there was a problem with any of these treadmills?
No.
Was Woodway ever put on notice of a acceleration problem?
No.
Were they ever put on notice of a stop button problem that you need to press down for the machine to shut off?
No, and what I would say is this is a one-off situation in the 5 years prior to this accident. That Woodway treadmill was there, and the plaintiff had also used it. So secondarily, she's a sophisticated user of this treadmill.
Well, the sophisticated user of a treadmill. What's a sophisticated? You jump on it, you press the button, and you start running. I mean, come on.
Okay.
Right?
Putting that aside, what I will say is this: the issues that the plaintiff's experts bring up are after the fact. The fact of the matter is,
But they don't have any alternatives. In other words, in trying to advance the design defect, that somehow the button is hard to push, et cetera, or even to suggesting that there was a software problem to cause the acceleration. Neither of the experts have come through with, okay, this is an alternative. This would have created a better situation, correct?
yes, twofold. With respect to the manufacturing of this particular treadmill at issue, it was at the Equinox for 5 years without incident. And the main claim is the operating software, the operating system. Had there been,
which Equinox did not.
No, from the day.
They did not, they put the machine back in service, they did no diagnostic, they recorded nothing after this woman flies into a wall and breaks her ankle.
Correct. And in fact, as you can see from the record, if there were issues with this treadmill, they did contact. There were work orders, and only 2 work orders in 5 years. So Equinox is very diligent, and the biggest issue in this case.
Well, I don't know that. I don't know that.
Well, with respect,
the fact that there are 2, I don't know that equals they were diligent.
Meaning to, as of noticing Woodway of any issues. The biggest issue here is, as you already said, is the fact that the minute after this accident occurred, everything that the experts are talking about are subsequent to. They're not the cause of. She turns on the treadmill. There's a witness that sees her on it. Whether or not how it's sped up, that was not from the manufacturing. It did not come off the line like that. Secondarily, the design, as Judge Shulman said, was not any different than anything else with respect to the operating systems. And there's no indication that the software was glitching or anything of that nature, so that Woodway would have had to change the design of the software and or the display, or that they should have recalled it. There's no recalls. It's similar to a car. It's similar to any other situation where you have a one-off of the situation. And what I would say is that the experts are looking from the conclusion to the beginning as opposed to the beginning to the conclusion.
And the experts, they never conducted any diagnostic testing of the systems.
No, because as noted, it was plugged in, plugged out, taken out. And also, 7 months later, the only expert, including my own, because we never got to see it, meaning Woodway, Koblinka, he could not replicate either the spontaneous acceleration and or this situation of the reset.
Yeah. So, but he did
some error.
He did notice an error, that there was a problem with the software. In his testing, there was something that did not go the way it should have gone. And so it wasn't same as this accident, but it showed that the machine wasn't exactly operating flawlessly either.
Well, I would say to that, 7 months later, when you start pressing a lot of buttons and nobody else is there to know what buttons you're pressing, I could probably have come up with an error on it. The fact of the matter is that
I don't know. If you shut a machine off and it's still going, that shouldn't happen.
But
no matter how many buttons you press.
That's not the proximate cause of the accident.
I said that.
So
I said that.
I'm gonna go sit down.
Okay, I said that. All right. Yes, it's okay. We're in the same boat. Counsel, your turn.
May it please the court, Aaron Fine, Meyerowitz, and Wasserberg for the respondent. Look, it is indisputable that taking the evidence in the light most favorable to Ms. Delusen, taking her account in how the accident happened, that she came to the treadmill, she pressed start, and within seconds it went from 0 to 6.6 miles per hour. She repeatedly pressed the off button. Not only did it not go off when she pressed it, it didn't go off when the Equinox employee pressed the off button. It didn't go off when the EMS workers came to press the off button. There's no dispute that that should not have happened. There's no dispute in the evidence that the only explanation for that is a software malfunction.
But we have no evidence of that, right? Because there was no diagnostic taken of the machine after this accident. So there's no way of assessing that information, right?
Well, with all due respect, that is the evidence of the software malfunction.
What? That what happened? What she alleges happened is the evidence?
Well, yes, but also to explain the fact that it's not disputed that the treadmill reset just by plugging it out and plugging it back in, and that allegedly resolved any issues with spontaneous acceleration. That is indication that there was an issue with the control board and the software. That is not disputed. So,
but isn't that speculation? We don't know why the machine malfunctioned. There could have been 100 reasons, since no one actually did any diagnostic. As my colleague mentioned, how do you draw that conclusion?
Well, because Woodway's own witness, the director of research and development, admitted that a software defect is what would have caused the failure to reset, the spontaneous acceleration. Beyond that evidence, essentially what it comes down to is this was a classic battle of the experts, and with all due respect, it wasn't much of a battle. Mr. Kobilka actually inspected the treadmill. As Your Honor mentioned, there was a defect, there was a malfunction when he did the inspection, although it wasn't the exact same malfunction. It
wasn't the defect alleged, right? That the malfunction that he saw was not the malfunction or defect alleged by the plaintiff.
That's correct, but it was of the same nature.
No, counsel, you can't. A machine that doesn't turn off is not the same as one that automatically speeds up. Those are two different problems.
I agree.
Now, they may come from the same source. I don't know. I don't think any of us know.
Well, there were multiple problems with the treadmill. That is the issue.
But didn't she use this treadmill for about 5 years and never had any issue with it?
I mean, she particularly said she chose this particular one because of its location. She didn't want anyone next to her.
That's true. There's also testimony from Deanna Bowman, the Equinox receptionist, who said that on at least 2 prior occasions, while she didn't know exactly which treadmill it was, there was a complaint about spontaneous acceleration.
She said it was on a different floor. It wasn't even on that floor. I think she was on the first floor, or did I get that wrong?
It was the first floor.
Right, and
Yes.
where is this treadmill located?
The first floor.
Also on the first floor?
Yes. So
She couldn't say whether it was the same one, though.
and she couldn't say that it wasn't.
right.
And again, I'll just remind the court, this was not my motion for summary judgment. It was not my burden to establish that. It was Woodway's burden. Now,
Are you saying they didn't meet their prima facie?
I did.
And if
Excuse me,
we
I do.
disagree with you, how did you controvert it?
Well,
If we think they met their prima facie burden, after all, this treadmill had been in Equinox's possession for over 5-6 years without a problem, without any real problem. So how is it that they are now on the hook?
Well, Mr. Ball, Woodway's expert, he admits, he says, I cannot say with a reasonable degree of certainty what caused this incident.
How is that proof of what did cause this incident? Which is what you have to establish this claim against Woodway.
At trial, yes. But here as
So
well.
how?
Because as a process.
On the basis of what I have in this record, the statement by the expert, I can't say is not proof of what it was.
Because Mr. Ball's report was a rebuttal to Mr. Kobilka's report. Mr. Kobilka, again, he inspected the machine. The machine was defective.
I know, and he did not get the same error. So how is that proof of this?
Because it was proof that the control board was defective. And the control board is what controls speed, controls its ability to reset, and its ability to turn off.
Okay. Thank you. You have 2 minutes.
Very quickly, with respect to the experts, it's not a battle of the experts. Mr. Kopelinka saw it without any notice to Woodway. Woodway was never noticed until the complaint, that there was even a cause of action against it. So that is number one, just goes to show you that nobody seemed to really be concerned about the computer software, the operating system. So I don't think that the experts at all really should weigh in.
So even after this plaintiff flew into a wall and broke her ankle in several places, Woodway was not contacted by Equinox and said, you know, there's a problem with this machine. There must be a problem with the software because one of our clients flew into a wall.
No.
You didn't get that call?
No, because the next day it was already plugged back in and used, and it was used between the time it was plugged back in until Mr. Kopelinka came. So I can't even, nobody, Mr. Ball and Mr. Abraham don't even know his methodology. So I don't know the methodology, neither does my expert, so that's already a question even for all the inferences in favor of the plaintiff, the methodology of how he got this error in terms of the turnoff. What I will say about the turning off, I want to remind the court, Mr. Fine just said, it accelerated within seconds, so it did not turn on at 6.6. Let's be clear. We don't know what she was doing. With respect to the turning off and that they couldn't turn it off, I just want to remind the court, she had broken her ankle and flew into the wall. Her leg was left on the treadmill. It was moving. There was frenetic and frantic. The easiest thing to do was try to press the button, although Mr. Hernandez, as the mechanic said, it needed to be held down for a second. She's not wearing her emergency button. And the easiest thing to do when this woman...
Is that the lanyard you're referring
The
to?
lanyard, that's that orange thing that everybody sees on that nobody uses.
You know why? Because if you back up a little, you stop the machine.
Right. And so one last thing. So I just want to say that the easiest thing to do is pull out the plug.
Right.
Thank you.
Thank you. Have a good night. And last but not least, People versus Christian Compres Moreno. You may proceed.
It pleases the court, Frank Schau for Mr. Compres Moreno. Multiple courts, including the Florida Supreme Court, have suppressed the exact same observation we're seeking to suppress here, namely that of my client sitting in the driver's seat. That is consistent with decades of practice in federal and state courts across the country, suppressing all types of observations of defendants committing unlawful acts. Now, respondent says that the fact that my client was sitting in the driver's seat is somehow a part of his identity and therefore cannot be suppressed. Respondent is wrong. Unlike all of the cases respondent relies on, we're not trying to suppress Mr. Compres Moreno's name. We're not trying to suppress government records about him, such as DMV records about him, and we're not even trying to suppress what his face looks like. Our point is that even if all of that evidence came in at a hypothetical trial for unlicensed driving, that wouldn't be enough to secure a conviction. And to see why, just imagine that this goes to trial, and Officer Batista testifies to two things. One, on May 8th, 2018, I stopped a moving Toyota. And two, on the same day, May 8th, 2018, I arrested Mr. Compres Moreno. The jury would immediately acquit on those facts because they would wonder, one, what is Mr. Compres Moreno's connection to this stopped Toyota? Was he even in the Toyota? Two, even assuming Mr. Compras Moreno was in the Toyota, we would want to know, well, how many people were in the Toyota with him? Was he the sole occupant, or were there other people there with him? And if there were other people there with him, they would want to know, well, who was in the driver's seat? In order for the prosecution to get a conviction at trial, they need someone to say, I saw Mr. Compras Moreno in the driver's seat. And that goes way beyond the narrow identity-related exception.
Counsel, 2 points.
Yeah.
One, and I appreciate the argument you're making, but if there was a valid waiver, as your friend contends was here, particularly in the translation, and I'm not going to repeat all that, but we both know the record, then your whole argument falls, correct?
If the appeal waiver is
Fair
valid,
enough.
yes, and of course we.
Secondly, let's go to another point. It's well recognized in New York case law that that DMV records that you are seeking to suppress or you believe should be suppressed are public and therefore would never be subject to any kind of Fourth Amendment issue.
Okay, so I'll try to address both points, Your Honor. First, I want to just clarify, we acknowledge that the DMV records could not be suppressed.
Okay.
And so at that hypothetical.
Isn't that the basis for the arrest?
Sorry?
His suspension, isn't that the basis for the arrest?
Well, they need two things. Well, they need to show that his license was suspended, and that we admit they could testify to at trial, that it was suspended on May 8th, 2018. But they also need to show that he was actually operating a vehicle on that day. If Mr. Compras Moreno was just sitting in the passenger seat in that car, he couldn't be convicted for unlicensed operation of a motor vehicle. And so that's the thing we're trying to suppress. It's the observation with Officer Batista's eyes of my client sitting in the driver's seat.
So the observation of his identity as the person in the car.
The observation
Driver's seat.
of him sitting in the driver's seat, that's
Well,
right.
that constitutes the commission of the crime. Since when do we suppress that from a police officer?
Yeah, so I
don't
can give you
understand.
3 examples, Justice Manzanet. I'll give you one example. Any case that involves contraband that's recovered from a defendant during the course of an unlawful search or seizure, not only is that contraband prohibited from coming into evidence.
Counsel, you know I know this, right? So that's not what we're talking about here. We're not talking about an illegal search and seizure. We're talking about a stop of an individual driving a car who wasn't licensed to do so.
Well,
and your request to suppress the observations of the police officer's stop.
That's right, yes. Well, by assumption, as this case comes to the court, we are assuming that the stop was unlawful because the trial court never actually ruled on the legality of the stop. It just said, even assuming you're right that the stop was unlawful, the thing you're trying to suppress, the observation of my client in the driver's seat, that couldn't be suppressed anyway because the exclusionary rule doesn't apply to it. And so because the trial court never ruled on the legality of the stop.
What are you arguing as a basis as to why the exclusionary rule applies to the officer's identification of your client as your client being the person in the driver's seat?
Sorry, could you repeat the
What's
question,
the
Justice Michael?
basis for your argument? What are you relying on?
Yeah, we're relying on the fundamental principle.
What case are you relying on for this proposition?
Sure, I pointed to you on one song which says that observations made by officers during the course of an unlawful invasion will be suppressed.
Okay, this is not an invasion. Continue.
Well, it's certainly an unlawful stop.
This is not an invasion. Continue. What else? What's your other case?
Sure, then I would point to the state's own concessions in the Tolentino case. And
the Tolentino case was ultimately not decided, right?
At the Supreme Court, that's right.
And based on the record, it seemed like the only person on the court who was entertaining the idea that it could potentially, an officer's observations could potentially constitute fruit of the poisonous tree was Justice Scalia, but Chief Justice Roberts, Kennedy, Breyer, Ginsburg, and Kagan all highlighted the impracticability of an application of the exclusionary rule for this. So there is no, Tolentino doesn't help you. The fact that certiorari was granted and then dismissed as having been improperly denied is not a case that you can kind of rest on for this, but I will hear you on rebuttal, okay? Counsel?
Good afternoon, Your Honors. May it please the court, Juliana Susu for the people. Just to start with the appeal waiver, the defendant's suppression claim is barred by his valid appeal waiver. The court thoroughly explained to defendant the appellate rights he was being asked to waive, and defendant also signed a comprehensive written waiver. Defendant's suppression claim is also forfeited because the motion court did not decide on post-op observations of defendant in its decision, and defendant never alerted the court to that omission. Beyond that, as this court already found in the Maldonado case, the officer's post-op observations of defendant are not suppressible despite the illegality of the search. An officer simply walking up to the window of the car that it just apprehended, looking at the person when asking for their ID, falls within the scope of identity-related evidence and cannot be suppressed. And as this court has recognized, the face and appearance of the defendant is not suppressible. Just going off of the other cases that my friend on the other side was relying on, those are distinguishable because in those cases you're dealing with evidence obtained as an exploitation of the arrest, not identity-related evidence, which is what we have here. And for those reasons, we'd ask that you affirm. Thank you.
Thank you. Counsel, you have a minute.
Thank you. I'd like to just make two brief points. The first is about Tolentino. I just want to talk about not what any justice said, but what the state conceded itself. There, the state, represented by then Solicitor General and now Judge Halligan of the Court of Appeals, was asked what would happen if you had an unlawful vehicle stop where the police officer approached the vehicle and saw the defendant drinking from a bottle of alcohol and had a person in the backseat bound and gagged. And the state readily conceded, of course, those observations of the defendant committing the crime, drinking alcohol, and also having the victim in the back would have to be suppressed. And then the second point I would like to make is that if this court is inclined to rule against us on the merits issue as opposed to the appeal waiver, I would just note that this exact issue is pending right now in the Court of Appeals in People versus Ahmed Aketa, which posed the exact same issue from the Appellate and First Department. And so I would respectfully ask the court at least hold off on deciding that issue until after the Court of Appeals
Was a
issues.
waiver, a valid waiver of appeal invalid waiver of appeal alleged in that case as well?
I don't believe that an appeal waiver is barring that issue, so they are going to reach the merits.
Okay, which means that here, if we feel the valid waiver, that there is a valid waiver, we can determine it because it doesn't matter.
Yes, of course, yeah, but I'm just saying.
All right, thank you.
Want
Just
to rule
wanted
against
to make
merits.
sure. All right.